Please be seated, my God. It's not, then you won't have to vote for it. They haven't talked.
All right, Mr. Heath.
Good morning, Your Honor. May it please the Court, James Heath on behalf of Leah Marie Swan. It's going to be case number 2024 CF 2810. Your Honor, we filed a motion to dismiss. It was set, or is set for hearing today at 2 o'clock. However, the state got up with me yesterday and advised that they're not going to traverse. So we're bringing it before the court this morning to try and dispose of the case accordingly.
That's correct, Your Honor. We have no basis to file a traverse or demurrer for this case.
All right. Motion's granted. Matters dismissed.
I'm sorry, Judge.
Dismissed.
Thank you, Judge. That's all I have before the court this morning. May I be excused?
Yes, sir. Good day.
Thank you, sir.
Mr. Cotton.
Morning, Your Honor.
Good morning.
Your Honor, I have Gabriel Spencer on your docket. He's incarcerated. He may be on the afternoon docket. Okay, well, we weren't sure whether he's being transported or not, but for the record, I'd like to, what we're going to do if the court is
Well,
okay.
case number, please.
Yes, sir, I've got two, 20. If I have him, I'd like him out here. That'd be great. 2016 CF 2350 and 2025 CF 2422.
Okay, I have the 2350. What's the other case number?
25 CF 2422.
You have the second case, Madam Clerk?
I do now, but I didn't have it set.
Okay.
They may be on separate dockets, if we could just let them run together. Okay, good. We weren't sure if he was going to be or
Okay.
not.
Go ahead, Mr. Cotton.
Judge, on Mr. Spencer's cases, I've met with Mr. Snell on that case. I've also just gotten back from the vet court staffing. I believe he's going to be referred to vet court. They're going to do an interview of Mr. Spencer, and when I spoke with Judge Mason this morning, they asked that I have him put on the 2/12/26 observation docket. I just don't know if that needs to be on the record here or if that's handled administratively somewhere else.
All right, so it's not been transferred to vet court yet.
No, sir.
And so we're on today for what purpose?
I think it was on for arraignment today, probably on the VOP, and if I could just on the VOP case, let the VOP run with the new law case, and
You had arraignment on the new case yet?
I waived arraignment, Judge.
Okay. Okay. So is it set on our docket, Madam Clerk, just for status? And you know me, Mr. Cotton, I want to be sure it gets another court date to be certain it doesn't fall off.
Yes, sir.
We set for 3/9 or 5/11?
Looks like it's already set for March 9th.
All right, so we'll leave it set for March 9, and if it rolls off of vet court, just double check the docket, and if it stays on this one by some mistake, just let us know and we'll move it.
I will.
All right.
Thank you, Judge. That's all I've got.
All right, thank you.
I appreciate
Good
it.
day.
Yes, sir.
Mrs. Swiatek.
Morning, Your Honor.
Good morning.
Your Honor, I've got Nissa Pierce in 25 CF 1974.
It was a good year.
Almost as good as 75.
All right.
Ms. Pierce is here. Give us wave. We've got a motion to perpetuate testimony that was stipulated to yesterday by the state, and a proposed order was forwarded to your office. I do have a copy if you,
If you've got the paper copy, let me see if I can. No objection, Mr. Gomez?
No objection, Your Honor.
All right, signed.
thank you, Your Honor.
Anything else on that? Just,
Yes, I do, Your Honor. I've got a motion to modify pretrial release, and there's no objection from the state.
That's correct, Your Honor.
all right, and you got an order on that as well?
I don't, I just got the no objection this morning. I'll have it over to you this morning.
All right, very good.
And that's all I have, Your Honor.
All right, thank you. Good day.
Thank you, sir.
Mr. Durrell.
Morning, Your Honor.
Good morning, Mr. Durrell.
May it please the court, Dustin Durrell, Your Honor, my client is Ms. Lindsay Rogers. That is 25 CF 267, 269, 1866, and 1867. We're here today on a motion to set bond. For those 4 cases, they're all 4 BOPs.
All right, you may proceed.
Yes, Your Honor. So Ms. Rogers, we're asking the court today to set a bond in the 4 violation of probation cases. Your Honor, we understand the position. Ms. Rogers comes to this court in, I believe she had recently entered a plea to those cases, was ordered to attend rehab. She was arrested, I believe it was about a week and a half later, and has been incarcerated since. Your Honor, we're asking, I've spoken with a Mr. Andrew Kendall, who's a Okaloosa County paramedic and does rehab outreach. He has informed me that there is a residential rehab that he can place Ms. Rogers in Baker. We are asking the court to set a bond, and as a condition of that bond, to enter that program and successfully complete that program. I'm sorry? Alternatively, Your Honor, Ms. Rogers is a single mother. She does have 4 children that are currently staying with her mother. Her mother is currently undergoing, has some medical issues. I believe she has not received a diagnosis yet, but is being, I guess, tested for lupus. Alternatively to the rehab, we would ask for a bond where Ms. Rogers would be able to stay with her mother, have community control sanctions placed on her so that she could be back with her children, help her mother take care of her children, given her mother's current medical situation. Caring for those children is presenting a significant hardship. I believe the mother is currently at the hospital this morning, otherwise she would be here, Your Honor. Ms. Rogers' grandmother is here as well. Probably have just a minute.
State?
Yes, Your Honor, we would respectfully request that this motion for bond be denied and the defendant remain incarcerated without a bond. On these 4 cases, she entered a plea to a negotiated downward departure, so she was given an opportunity. That happened, I believe, on November 20th of 2025. She pled to 5 years of probation with inpatient treatment at the Home of Grace in Alabama. She was released from jail on a Thursday, and she did not go home. I hear the defendant claiming that she just wants to go out to be able to take care of her mother, but instead of being found taking care of her mother, she was found and arrested for DUI, leaving the scene involving more than $50 worth of property damage, a DWSR HTO, and then a refusal to submit to testing that following Friday night, Saturday morning. Simply put, Your Honor, under the 903-046 factors, she was out on probation. She was given an opportunity to voluntarily enter this treatment program. She chose not to do that. She chose to drink. She chose to get behind the wheel of a vehicle and put not only herself in danger, but the community. So because of committing a new law violation while out on bond, we would respectfully request that the motion for bond be denied and she remain in custody, Your Honor.
And in which case is the new case that you're referring to? Is that the
It is.
2323 case?
This is, I just pulled it up. Yes, Your Honor, 25 CF 2323.
Your Honor, may I speak?
Talk to your lawyer first.
And Your Honor, I apologize. I think I forgot to mention Mr. Kendall, as part of what he does, he would personally take Ms. Rogers from the jail to the rehab. ACR calls him and he comes and picks up the inmate and takes them to the rehab.
So I'm just trying to review she pled to the VOPs, she pled to the cases which generate the VOP. Was that on 11?
I believe it was November 20th, Your Honor.
20. Is that right?
That does sound accurate, Your Honor, yes.
And on 11/29 is when the new charges arose.
Yes, sir.
Yes, Your Honor.
And whatever reason, I don't actually see the,
And Your Honor, as far as the new charges go, I've yet to receive discovery in that matter. All I've been able to see is the arrest report, so I'm not very prepared to discuss that matter.
no, I understand. I haven't, all I see is the first appearance paperwork.
Yes, Your Honor, that's about all
So-
I've got so far, too.
Yeah, so I'm just, and I don't actually see the written plea agreement in the record. Maybe it's in a different,
When I was preparing for today, I believe I had to pull up the minute sheet, and there was several notations about the plea on the minute sheet, but I didn't see a written plea agreement either, Your Honor, in any of the 4 VOP cases. I don't know if it's still being processed or not, but I wasn't on the original cases for that plea, Your Honor.
Your Honor, it's uploaded in 25 CF 267.
267, you say?
Yes, Your Honor.
Okay, thank you. And so it appears that she was released on 11/20 on the plea, and the plea provides that attend and complete inpatient treatment at Home of Grace in Alabama and complete any recommended aftercare treatment. Must follow and complete all treatment plans recommended. No consumption of alcohol or controlled substances without a prescription. Testing to confirm that. After inpatient treatment is concluded, or as soon as employment is permitted and encouraged by Home of Grace treatment team, defendant must maintain gainful employment or submit 4 job applications. Is there any evidence that she ever entered the inpatient treatment at Home of Grace in Alabama State?
Based on my notes, no, Your Honor.
I don't believe so, Your Honor.
Yes, sir. So, and since it appears that and just looking at this, we have 25 CF 267 retail theft, 25 268 retail theft in concert with either 2 of those, 269 grand theft, 1866 grand theft, more than 5,000 less than 10, 1867 possession of controlled substance, 1867 possession of paraphernalia, MM261 petty theft, MM262 petty theft, MM523 petty theft, MM2881 petty theft, MM2881 possession of drug paraphernalia. The present charges for which The court has found probable cause are DWLS while habitual, a refusal on a DUI, possession of drug paraphernalia, and leaving the scene of a crash with property damage. These seem to be consistent with the circumstances presented in the original plea and the fact that she willfully and intentionally, as alleged, violated her terms right out of the gate. The court doesn't believe she's a candidate for a bond, and the motion will be denied.
Thank you, Your Honor.
Are we going to track the VOPs with the
Yes, track the VOPs with new case. Is that okay,
Yes, please,
Mr.
Your Honor. I
Durrell?
believe the new case is set for March 9th. Is that correct?
Yes.
Excellent. Thank you very much, Your Honor. That's all I have today.
Thank you, Mr. Durrell. Good day. Ms. Dudley.
Your Honor, this will be Cole Graninger, and 18 CF 2247 and 18 CF 2460. I just need him to sign this real quick, Your Honor.
Say again?
I just need him to sign real quick. We did go over it.
Yes, sir.
Your Honor, this is Cole Graninger. I don't have the case numbers in front of me. I gave you the.
That's all right.
It's
So
fine.
it's adjudication of guilt,
Yes,
the
sir.
fees and costs, 12.45 months Department of Corrections, credit for 10 months and 13 days, revoke and terminate probation, cost to judgment.
I just included what the credit was from so that if the court had any questions.
Right. And you say originally sent,
He originally served 9 months on the original case, plus he got arrested, so that makes it 10 months, 13 days.
I see. So you're
Yes, sir.
just putting that clearly on the plea
Yes,
agreement?
sir.
So
Okay,
that DOC will know how to credit for the time he served in
Correct.
Mississippi on the active warrant?
Correct. Your Honor.
All right, raise your right hand for me, please. You swear or affirm testify truthfully in this matter under penalties of perjury?
Yes, sir, I do.
You can put your hand down. Now, you've reviewed this plea agreement with Ms. Dudley and signed it.
Yes, sir.
You understand that you're admitting the violation.
Yes, sir, I do.
And that says to me, Judge, I violated my probation just the way the affidavit report filed by my officer says it
I
did.
take all accountability.
All right, and by doing this, you understand you're waiving your right to a hearing where the state would have to prove you violated.
Yes, sir.
In this case, you'll be adjudicated guilty if not previously done so, and you'll be sentenced to 12.45 months Department of Corrections with the credit we discussed, and you'll have an additional $100 VOP prosecution fee each case, and all of your costs will be sent to a judgment. Is that your agreement?
Yes, sir.
Has Ms. Dudley answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how she's represented you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and accept the plea.
Yes, sir.
Thank you. Step this way, please.
Your Honor, the state will submit a score sheet. We do stipulate it'll be 12.45 months DOC.
All right, very good.
That's correct. Your Honor, may I approach real quick?
Granted.
Your Honor, that's all I have. Thank you.
Thank you, Ms. Dudley.
Mr. Gomez?
Yes.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview Historic Main Street. We serve handmade pastries, espresso.
Don't make it up here often enough.
That's a
John
shame.
Madden.
That's a shame.
Yes.
You should be here more often.
Maybe just a visit. John Madden here on behalf of Demetrius Warmble.
And
Your
what's
Honor,
the case number, please, Mr. Madden? I'm just trying to help the court reporters make a good record, and it lowers their overhead if they know what the case numbers are.
yes, sir, 23 CF 2473.
All right, thank you.
I spoke with Mr. Snell this morning. We are in negotiations on this case. I've also talked to him about a few items of discovery that I'm requesting. So if I could get a continuance to get those as well as continue negotiations in the case, Your Honor.
State?
The state has no objection, Your Honor.
All right. And this is a VOP, correct?
Yes, Your Honor.
All right, Madam Clerk?
January 22nd or February 12th?
Could we get the 12th, Your Honor? I think I have an engagement on the 22nd.
All right. 2/12. Is that with subpoenas or without?
Without, Your Honor. We're not ready at this point for a hearing, or at least the defense isn't. And it wasn't indicated to me by the state that they're ready for that either.
State, you agree? No subpoenas?
I would agree, Your Honor.
All right. No subpoenas, Madam Clerk.
Thank you.
All right, very good, thanks. Thanks, Mr. Madden.
Thank you, Your Honor. It's good to see you.
You as well, sir.
Good morning, Judge.
Good morning.
Jared Sutherland here on behalf of Mr. Michael Foster. This is case number 02-CF-617. This is a very complex and procedurally heavy case. It is our position that Mr. Foster should not be on the underlying period of probation, which he's alleged to have violated. Back in 2005, the state attorney's office filed a motion for a legal sentence and seems to have concurred with our position that there wasn't a legal sentence proffered originally in this case. I have the original plea agreement, which indicates that Mr. Foster pled no contest to 3 counts of vehicular homicide with a maximum penalty incarceration of 15 years. He was sentenced concurrently on counts 1, 2, and 3 to 15 years in prison. He served all of that time in prison and was released, and the plea agreement had him also sentenced to 15 years of probation upon his release from incarceration in DOC. So he served a maximum penalty on counts 1, 2, and 3 concurrently. I have the offer here, which he had agreed to, which was filed with the clerk of court on April 30th of 2003. And then he was additionally sentenced to 15 years of probation concurrently on those same charges. He's now here for a violation of probation based on a new law offense over in Panama City. I just got all of the procedural documents in this case on Sunday night, actually, and I've been reviewing those. But upon my review, I did see that the state attorney who was previously on the case seems to have concurred with what our argument is in court today and filed that motion for a legal sentence. Now, the state attorney's motion asked for this court to correct the sentence prior to Mr. Foster serving those 15 years concurrently on each count. However, it appeared from my review of the record in this case that no court ever corrected the sentence according to the motion which was requested by the state, which would have corrected the sentence or modified the sentence to having him serve 15 years concurrently on counts 1 and 2, followed by 15 years of probation on count 3. However, no order was ever issued which modified the sentence accordingly. So at this point, Mr. Foster has served 15 years on all 3 counts concurrently in DOC, and it is the defense's position that if the court were to retroactively modify the sentence, that would be a manifest injustice based on the fact that he has served the 15 years on each count concurrently before any modification was made. And so today, Judge, we would ask that you dismiss the violation of probation and discharge his probation requirements. And if the court is not willing to do that at this juncture, we would request that you consider a release on his own recognizance bond to allow him. He has retained private counsel on this case. He's retained private counsel on the case in Panama City. And with the procedural issues that may arise in this matter, we are asking that the court consider an ROR bond to allow him to effectively defend himself while these allegations are pending.
All right, so I'm just looking at the progress docket and getting my feet under me here.
Yes, sir.
I see on 8/16 of 2005, the state filed a motion to correct the illegal sentence. That's what you're referring to, correct?
Yes, sir.
And then,
And I never saw any hearing on that or order from that, so if the sentence...
well, and I'm confused too, because I see on docket identification number 106, it says order denying motion for post-conviction relief.
That was a prior motion, Judge. There was 2 motions. There was one motion for post-conviction relief, which was filed originally. That was relating to community service hours. Then, after the fact, a motion for a legal sentence was filed by the state of Florida. And that motion basically tracks...
So the order at 106 referred to is for the defendant's motion that he filed?
Yes, sir. That would be the prior motion, the motion prior to the motion filed by the state of Florida. So there was...
And so that was, it looks like that was docket identification number 97, maybe,
yes,
on 6/23?
I'm not exactly sure which the number is, but I do know there was 2 motions filed, one by the defendant. That one was handled and ordered by the court. However, the one by the state, which is the argument that we're making today, I don't see any indication that that was ever handled. And if it was not ever handled or addressed by the court, then Mr. Foster would have effectively served his maximum sentence on each case.
Right, and then interestingly...
Can I jump in here?
Yes.
Real quick? We're here for a VOP arraignment. I'm covering for Mr. Little. None of this has been noticed. We haven't been noticed for a bond reduction. We haven't been noticed for any arguments being made for a dismissal. This is just a VOP arraignment. And so the state is respectfully going to request that if he wants to make arguments for a dismissal, he puts that in motion. If he wants to motion for a bond reduction, he puts that in motion. We properly notice the court, and then we put it on a date so that Mr. Little can adequately prepare and then make these arguments. I'm in a position right now where I can't really make any arguments for or against what we're talking about because A, I'm covering for somebody, but B, this wasn't noticed. And the only reason why I'm covering is because this wasn't noticed. Otherwise, I know for a fact Mr. Little would have been here. So I think right now this is a little bit premature to discuss dismissing a VOP.
Right. I understand what you're saying, but at the same time, looking at the state's motion from 2005, it says very clearly that the state concedes it's an illegal sentence. and that it should be modified.
And that is the defense's position, Your Honor.
And so I will, I understand your position, you need time, but if it is in fact as described by the defense, it needs to be set ASAP.
I would even be okay with setting it for a week, but I think in this, a week later, but in this situation of, or.
But that's my point. I'll continue this to next Thursday during our pretrial detention hearings, 12:30. And the state needs to be prepared to address that. Once again, I'm not aware, I wasn't aware of this until it was brought to my attention just now, Ms.
Yes, sir.
But it seems, and so I'll give you those DINs again. It looks like the DIN of the state's motion was DIN 107, 8/16/2005. Mr. Elmore signed that. And then inexplicably, there was a order of modification on DIN 109, which says that the defendant can do his community service in lieu of the fines, fees, and costs, I believe is what it says.
Yes, sir, and that was for the prior motion filed by the defense. And the reason why we have not filed a motion yet is because I just got all those documents and the procedural stuff in the case on Sunday.
I understand.
Yes, sir.
I understand. It's a whirlwind.
Yes, sir.
So, and the VOP is,
And so I guess, Judge, would you like me to file a additional motion in addition to the state's motion, which is basically agreeing with the state's motion at this? Because I do know the state already had a motion pending that simply.
notice the state's motion for hearing, I
Yes,
guess.
sir.
But I think Mr. Gomez is correct.
Yes, sir.
Being aware of that and having the opportunity to review and
Yes, sir.
would be something that, in the, that they would need, they're entitled to notice and opportunity to be prepared. So
Yes, sir.
we'll set it for the PTD docket on, what's that date, 1/22?
Yes, sir.
We have a miscellaneous date then, though, don't we?
Yes, sir.
Yeah, let's set it just on our regular miscellaneous at 9 o'clock, and not
Yes,
the
sir.
PTD, because we don't know what's happening. Inform Mr. Little what's going on. You know the docket identification numbers of the motion, and let's proceed from there. Because the other part of it is if I'm aware of what's going on, I think the defendant is otherwise detained from the other case, correct?
I believe, do you have a bond in the other case? Yes, he has a bond in the other case, and I believe you'd be in a position to post bond if he was out.
Right, because he's not entitled to a bond because the new charge, both these charges will make him
Well, he
felony
would
offenders.
be, the only thing that's holding him without a bond right now, to my understanding, is this violation
Right,
of probation.
well, what I was saying is because of the new charge and he's on probation, this makes him a violent felony offender of special
Yes, sir.
concern for which he is not entitled to a bond.
Yes, sir.
So I want it resolved ASAP.
Yes, sir.
And we'll set it next week so that the state has the opportunity to review and be sure that there's no issue from their point of view in regard to this case.
Yes, Your Honor, thank you so much.
Absolutely.
Denying the VOP or continuing the arraignment?
Well, I think we're going to continue the arraignment because I don't think Mr. Sutherland wants to be in a position to even admit that the VOP is appropriate.
Yes, sir, we are, our position is that he never should have been, he shouldn't be on probation right now.
Correct. I understand. So we'll just continue the arraignment at this time.
Thank you, Your
Okay.
Honor.
All right. Good deal. And simply engage with Mr. Gomez is sitting in for Mr. Little. So Mr. Little will be covering this case, so you might want to engage directly with him to be sure that your arguments are properly formatted. I'm not saying Mr. Gomez won't do it, but since he's going to be hearing it, it might expedite the process since Mr. Gomez is going to be in court all day today.
Yes, sir, I'll do that.
Okay? All right. All right. Matthew Gunn, please.
Jason McKinney on behalf of Matthew Caleb Gunn. He is present for the court in 20 CF 2299. It is on the 9 o'clock docket. This is a violation of probation. At this point, we have reached an agreement with the state for an admission to the violation of probation. The modification that would result would add 8 hours of community service per month for the remainder of the supervision, and modify to delete the speech or seminar requirement, which is the basis for this violation of probation. There's a $100 BOP fee and a $150 cost of defense. Outside this agreement, Mr. Gunn is going to request that the court consider waiving the cost of supervision in this case, and I believe that the probation officer that's assigned does not have an objection to that. He did lose his employment at Miller's Ale House, thinking that this was going to result in incarceration. May I approach?
Granted. All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
All right, and you put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
Yes, sir.
Do you understand you're admitting the violation?
Yes, sir.
And by doing that, you're telling me that you, in fact, didn't do the things you were supposed to do as directed by your probation officer?
Yes, Your Honor.
And you're waiving your right to a hearing to where the state would have to prove that?
Yes, Your Honor.
And the modification is the additional community service per month and deleting the other conditions that were discussed plus the additional costs.
Yes, Your Honor.
Mr. McKinney explained to you the consequences of this plea and how it affects you?
Yes, Your Honor.
And you satisfied what he's done for you?
Yes, Your Honor.
The court will find the plea to be freely and voluntarily entered into and will accept the plea.
Thank you, Judge.
All right?
As to the cost of supervision, as the court...
Waive the cost of supervision until he regains full-time employment.
Thank you, Judge.
All right?
Your Honor.
Yes, please.
Your Honor, I have Ms. Mearns. She is present and approaching. This is case number 23 CF 1805. Your Honor, we're asked to continue this. My client was close to finishing her treatment. Unfortunately, she missed a second appointment, and if you miss 2 appointments, you have to start over. So she's got to start the 8-week program over. When do you start?
I can start this week again. I have the first appointment, so
When's your appointment?
I don't have one yet.
So you just need a second appointment?
Yes.
So, Your Honor, we're going to ask you to continue this. I talked to the state. They're okay with that.
And the treater is agreeing to re-accept them.
She has to just set the appointment.
Yes, I just have to redo everything again.
Okay.
I have no objection. I think it might be beneficial to set this out 8 weeks to give her time to complete the program. 'Cause
Yes, however, I will, as part of that, I want evidence provided as soon as she starts so that we don't wait 8 weeks only to be back in the same position. So I'll reset it for 2 months, Madam Clerk. That would be
March 12th.
Say again?
March 12th.
3/12. But as soon as you get reestablished, you need to provide Mr. Cochran a letter saying you're readmitted so he can give it to the state. If you don't do that, then they're going to put it back on a docket, have you come in and explain why you're not doing needs to be done, okay? The goal here is to keep things progressing, but also provide accountability, all right? All right, thank you.
All right, give me 1 second. Next, Your Honor, I have Mr. Tyler Lunsford. Case number 23 CF 1483. Your Honor, we're going to ask to continue this.
1483?
1438.
Okay,
Sorry, dyslexic.
okay. Thank you.
We're going to ask to continue this. He has completed his community service hours. It needs to be verified by probation. But at the same time, we're requesting that the court convert court costs and fines to community service hours, so that he can work on that rather than have to pay those to get off the probation.
Does the state agree?
So there's no objection to that, Your Honor.
So that's granted. You'll need to get an order that says that so that the record's complete, and so probation will have that, okay?
Yes, Your Honor.
And once you work this off, please let your attorney know, because then I'll go ahead and file a dismissal for the VIP, so you're not having to come back to court.
Thank you.
All right, next date, Madam Clerk. Do you think 3/12 is going to be enough time for you to get that all done?
Yes, sir. Yes, sir.
Okay. All right, 3/12 it is. All right, thank you now.
Thank you. And I'll get an order, Your Honor.
All right, thank you, Mr. Cochran.
Next, Your Honor, I have Mr. Luan Nguyen. Case number 23 CF 2595. Your Honor, Mr. Nguyen is also on the 130 docket. With case number 25 CF 2372.
All right, let Madam Clerk get up to that. Okay, yes, sir.
Okay. For the VOP, Your Honor, I'd ask to continue this to 3/9 so it can follow with the new law. There may be a motion in that case. As for the new law, the 25 CF 2372, I believe the information has been filed. We will acknowledge receipt, that's the information up there.
Granted.
We'll acknowledge receipt of the information, waive formal reading, enter a plea of not guilty, and ask to leave this set for the March 9th court date.
So ordered.
Are we denying the VOP except for limit today?
Yes, the VOP is denied. Right, isn't that what you said?
Yes,
Mr. Scott? Okay. All right, stay in touch with your lawyer, be back on March 9th.
Yes, sir.
All right.
Thank you, sir. Have a good day.
Yeah, and then call my office in 2 weeks or something. Thank you. And then, Your Honor, I have Mr. Kaisi Maston, 22 CF 2907. There was confusion with the court dates. That's the gentleman that lives in Georgia. He thought he had court Monday, the 19th, rather than the 15th. And he did email me earlier this week to verify it, and with my schedule being in court all day, I was unable to respond to him. So I would ask that we set this for next week.
122,
Yes, Your Honor.
is that okay with the state?
Yes, Judge, it is, given the circumstances.
All right, 122 it is.
Thank you, Your Honor. That's all I have out of custody for right now.
All right. Mr. Koch, anybody out of custody?
Negative, Judge.
Okay.
Please grab something, partner. I got something to address real quick.
Can we call Mr. Taylor's personnel?
Yes.
Your Honor, if we could pause my case for about 10 minutes. I would
Yes, sir.
appreciate that.
That's fine.
Yes, sir.
I got some easy ones we can address, Judge.
Okay.
First one, last name Rogers, first name Joshua, 22 CF 1852.
All right.
Judge, last time we were in court, the state stated, and also myself, my client is deceased. I do see there's an order terminating probation that was signed on December 16th.
Okay. All right.
Judge, my next...
From the docket, Madam Clerk.
Thank you. My next case, last name Powley with a P, first name Cameron. This is 25 CF 1876.
Yeah, I show that we set that for PTI review on 3/9.
That is correct, Judge. I was a little confused why I was on today's docket, but that is exactly what we're doing.
Just keeping you on your toes.
Yes, Judge. And my rest are all in custody. I'll turn it over to Mr. McKinney if he's ready.
Judge, all my cases are in custody.
Your Honor, there is a gentleman here from the 130 docket.
Okay, who is that?
Mr. McNabb.
Okay. Come on down, Mr. McNabb. Give Madam Clerk a chance to get her minutes. And that's the 2439 case?
Yes, Your Honor.
All right. Good morning.
Good morning.
We're not appointed yet, Your Honor.
Just a copy of the information.
All right, you're here today without an attorney. Would you like an attorney to represent you? Or would you like to hear what the state may have to say first as far as disposing of the case?
Yes, sir. I would like to have an attorney.
All right, you able to afford an attorney on your own?
No, sir.
All right, have you completed the application for the appointment of an attorney?
No, sir.
All right, one will be given to you now, complete it. It's a goofy government form, so take your time. What I like to do is have you complete it here, pass it back to the bailiff, and then I review it to be sure that it's complete, so that we try to do it just once instead of doing it over. Don't leave until you turn it in and get a new court date, okay?
Mm-hmm.
All right, thank you. We have some other folks in the gallery. Are you here today for your own case, or are you here for someone who's incarcerated? Okay. All right. We're going to take a 10-minute comfort break. Yes. Okay, very good. We'll take that, and then we'll take our comfort break. Say again?
Philip Wilson, 22 CF 166.
You can stay in your chair, sir.
You're fine. You're fine.
Sir, you're fine to stay.
Oh, you're fine there. Did you have a full chance?
God, this is so slow this morning. What's going on?
Judge, this is Philip Randy Wilson before the court in 22 CF 166. This is a violation of probation that is financial only. The third ground related to a vehicle, Mr. Wilson does not have a vehicle. This was violated at the end of term. He was supposed to term tomorrow. The agreement with the state is for an admission to the violation of probation, adjudication of guilt. He was previously adjudicated. Probation will be revoked and terminated with an additional $100 BOP fee or $150 cost of defense. That's going to leave the costs. We would ask the court for a period of time to pay off those costs prior to them going to collections. May I approach?
Granted.
And this is a guideline sentence. I believe Mr. Gomez is working on a score sheet.
All right. Mr. Wilson, can you hear me?
Yes, sir.
Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, sir, you can put your hand down. You heard what Mr. McKinney said on your behalf and signed the written plea form?
Mr. Wilson is hearing impaired. So.
All right. Did you talk to Mr. McKinney and read the plea form?
Yes, sir.
And did you sign it?
Yes, sir.
Do you understand by this plea arrangement that you're admitting the violation?
Yes, sir.
That tells me, yep, Judge, I violated the way the probation officer says I did. Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
And you've been previously adjudicated guilty, and your probation is going to be revoked and terminated. You'll have some additional costs imposed, and I'm going to give you 3 years to pay all your outstanding costs, okay? Mr. McKinney, answer your questions about the plea and how it affects you? Did he answer all your questions, Mr. McKinney?
No questions.
No questions? You satisfied with what he's done for you?
Yes, no questions.
Okay. Are you satisfied with what he's done for you?
Yes, sir.
I'll find a plea to be freely and voluntarily entered into, and I'll accept the plea. Thank you.
Thank you, Judge.
All right, we'll take a 10-minute comfort break.
All rise.
Get your folks all lined up. If you need anything,
All rise.
go ahead and take care of it, okay?
Yes, Judge.
All right. All right, it appears that you do qualify for the appointment of an attorney at the state's expense. I'll appoint the public defender to represent you. The clerk will review that. If they say you don't qualify, they'll tell you why. If you think they're wrong, collect all the information you have that shows they're wrong, give it to your lawyer, and bring it with you to court next time, okay?
Thank you, Your Honor. Today, we acknowledge receipt of the information, waive formal reading, enter a plea of not guilty, and ask to leave this set for the next court date, which I believe is March 9th.
That's correct.
Okay. So your next court date is March 9th. This is yours. This is my card. Call my office and make an appointment. Call them a week or two to make an appointment. I think it's going to take time to get you in the system. That's yours.
All right. Rochambeau. Let's go.
Can you hold on Jackson? I've got to hand him the plea agreement.
Actually, skip 10, we're not going to get a plea agreement for him. So 11, 18, 17, 11, 17, 18.
Are we starting?
Whoever comes out the door.
I like it. You gotta be quick on your feet.
That's like I said, the whole lottery machine. Bloop, whoever pops up.
So if I were to guess, it would be Valentine.
Louis Valentine.
How are you? Doing all right. This is everything we talked about the other day. Any questions for me? Could you read it? Yep. Yeah, sign it, take it right there. Judge, this is Louis Valentine Jr. before the court in 23 CF 1775. This is a violation of probation. We've reached an agreement. He's on probation for misdemeanors only. The agreement with the state is for an adjudication of guilt, 60 days in the Okaloosa County Jail with credit for time served. That will revoke and terminate his probation. I needed to write, I didn't write in the costs. And so it's 150. Okay, do you have any question about that? No, sir. Standard cost for the violation of probation. If I did not just announce, it's revoke and terminate the misdemeanor probation. May I have a motion?
All right, raise your right hand, please. Do you swear affirm, testify truthfully in this matter under penalties of perjury?
Yes, sir.
Can you put your hand down? You heard what Mr. McKinney said on your behalf and signed the written plea form?
Yes, sir.
You understand that you're admitting the violation,
Yes, sir.
waiving your right to a hearing where the state would have to prove it,
Yes, sir.
and you'll be adjudicated guilty if not previously. Your probation will be revoked and terminated. You'll be sentenced to 60 days in the county jail, credit for all time served, with the additional fees and costs that were announced. And how much time do you need to get everything paid once you're released?
A few months.
May I have a moment, Judge?
Yes.
Judge, from here, he's going to be going to Escambia, so I'd ask for a little bit more time than that.
All right, a year to pay?
A year would be fine.
Yes, sir.
All right. I'll find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Thank you.
Okay. Yes, sir. You too?
Christopher Carpenter.
Judge, this is Christopher Carpenter before the court in 16 CF 1849. This is going to be prosecuted out of CAC. This is a violation of probation arraignment today. We're going to be entering a denial and ask for a court date to be set without subpoenas. I would ask for the second date in February. That will give my office a chance to get up to speed with the ASA who is going to be handling this case.
Madam Clerk?
February 19th.
219, no subs.
Thank you, Judge. So, February 19th? Okay. And I'm going to try to get all the information I can from Ohio, and then we'll go from there.
Dejan Kimbrough.
Just like we talked about.
Frank, if you would take number 2 back out of the conference, we'll have 2 more.
Well, I thought someone was there. The other one's there.
Judge, this is Mr. Kimbrough before the court in 17 CF 3377. This is an arraignment for a violation of probation. We're going to enter a denial and ask for this to be set on the 19th February. This is being prosecuted out of the CAC, and I'd like an opportunity to review the case with them.
No subs?
No subs.
All right, 219.
As soon as I get it off, I'll come back.
Next, we have Brian Pittman with Mr. Kelly.
Thank you. Your Honor, this will be an admission to the VOP. Just need you to sign right here. Coming back. Yeah, question. Your Honor, before the court is Mr. Brian Walker Pippin, case number 23CF03. It's a violation of probation, Your Honor, through urine tests. What we would like to do is admit to the violation of probation. Mr. Pippin would like to do that, and we don't have an agreement with the state, Your Honor, and what we would like to do is set it for sentencing. The state's position is 1129, and we're asking for the court to set it for sentencing. And I explained to him all the ramifications of what the court may do and what the court may not do, what the court can't do, and what his exposure is. And with that, Your Honor, we leave it to the court.
What is his exposure?
I think it's 15, Judge. Is that right, EJ?
It's, no, it's 6.
It's 6.
6
I
total.
apologize, Judge.
So the state is asking for 1129.
Correct.
With the VOP points, Your Honor, just for your knowledge, he scores 43.4 total score sheet points. So he's right under that threshold for a DOC sentence. I mean, you could theoretically impose a DOC sentence. We offered 1129 to resolve it today.
We got to withhold the adjudication, Your Honor, on the charge. He doesn't have to be prior felony. There were, the reason for the violation is 3 tests that tested positive for dirty air.
And so you want to go to sentencing right now, or you want to set it for a sentencing hearing?
We would like to set it for sentencing, Judge, maybe 2 to 3 weeks away. We're not asking for a PSI.
Okay.
We're asking for the court to accept the admission.
All right, because he is violent felony offender of special concern, correct? with this charge?
Yes, sir.
Okay. And adjudication was withheld.
Correct.
And the state is currently offering the 1129 with an adjudication?
That's correct, Your Honor.
Okay. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, you can put your hand down. And you understand by this plea arrangement that you're pleading that you're admitting the violation?
Yes, sir.
And that says to me, Judge, I violated just the way the affidavit report says it did.
Dirty hearing, yes, sir.
And do you understand by doing that, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
And Mr. Catalinix told me now that he's discussed with you the fact that there's no agreement regarding your sentence.
Yes, sir.
All right. And what that means is that the sentence is completely up to me. And it's not a humorous situation, but I try to use stupid examples to explain what that really means. All right? So, yeah, and I used to use my wife as an example, but everybody told my wife I was talking about her in court, so I don't use her as an example anymore. So I'm driving over here, enjoying a cup of coffee, and somebody cuts me off in traffic, and I spill the coffee in my lap, and I come into court, and I'm just mad. And I take it out on you, and I sentence you to 15 years in prison. It might not be the right thing to do, probably the wrong thing to do because I'm mad, but it will be legal for me to do that based upon this plea arrangement. Do you understand that?
Yes, sir.
Because you're leaving it totally up to me. You understand that? Now, I'm not saying that's what I'm going to do, but you need to understand that it's absolutely up to me. And since you got the more than 22 points, you're eligible for a prison sentence, and that can happen. Do you understand? Now, Mr. Catalinix told me that he wants a hearing where he can present evidence on your behalf about what a reasonable sentence should be under the circumstances. And that's why he wants to do it this way. So he wants the opportunity to present that to me to explain why he thinks the state's offer is not reasonable under the circumstances and to tell me what a reasonable. I'll listen to that and do my best, but ultimately it's going to be up to me to decide. Do you understand?
Yes, sir.
Are you still willing to proceed with this plea?
Yes, sir.
Okay. The court will find the plea to be freely and voluntarily entered into. We'll accept the plea. When do you want to set it for sentencing, Mr. Kennedy?
Whenever the court finds it convenient, Judge, I'm free for the next 2 months.
All right. So we need to set it in the afternoon. Can you be, next week is pretty chock full, isn't it? What about the first day in February? All right, so let's set this for the afternoon of February the 12th at 2:30 for sentencing, and be ready to take care of it then, okay?
That was at 1:30, sir?
2:30.
2:30, yes, sir.
It'd be at 2 p.m.
I'm sorry, thank you very much for correcting me, 2 p.m. 2 p.m.
You late.
We changed the time, and, you know,
I got it, Judge.
2 p.m. Creature of habit, just like I announced Monday last,
Lincoln's birthday.
when it's a holiday.
I think
All right,
that's
so,
Lincoln's birthday.
say again?
Lincoln's birthday.
That's true.
Yeah, I got that. Jeopardy.
All right, and so we'll see you then. All right, thank you.
William Martinez Gonzalez.
Good morning, Your Honor. We have Mr. William Gonzalez. Case number 2018 CF 2955, 22 CF 2219, and 25 CF 0761. Your Honor, we're going to deny this morning, ask to set it for the next court date without subpoenas, we are working on plea.
All right, so 212,
Yes, Your Honor.
no subs.
No subs.
All right. All right, so ordered.
Thank you. This will be Judson, Roberts, and Mr. Cox.
Judge, this is Mr. Judson, last name Roberts, 24 CF 2225. Your Honor, speaking with the state is going to seek a second evaluation in this case, Your Honor.
All right. Sorry for the delay, but things are just running slowly today. And the report, the evaluation that we have is the evaluation by Dr. Benson, correct?
That is correct, Your Honor.
From
Creekside.
from Creekside, looking like evaluation done 11/18. And so the state intends to seek a second?
That's correct, Your Honor.
All right. All right, so how far out do we want to set this?
Judge, if I may request, if we could put this on the February 12th date, just for a status. We don't need to transport my client if the court's going to have the eval, but I just want to keep tabs on this, want to make sure that we're moving along.
So status only?
On the 12th, if I may request that.
All right, status only the 12th. Do not transport the defendant.
Thank you, Judge.
All right, thank you.
Next we have Deontay Smith.
Your Honor, this is Mr. Deontay Smith. I have two case numbers, 23 CF 1700, 24 CF 799. Judge, we'll be entering a denial in both cases. Speaking with Mr. Snell this morning, the current offer is going to be placement in Keaton, bars to bed. I'm requesting to set this for the February 12th date without subpoenas so I can get my client evaluated.
All right.
No objection from the state, Your Honor.
Do you need an order, or is it going to be a confidential?
No, Judge, I don't need an order. This just to get Keaton to get him evaluated. I apologize.
A Keaton evaluation?
Keaton, yes, bars to bed for treatment.
All right. All right. And you think 212 is going to be sufficient?
They've been moving pretty quick on these, so if we may put them on the 212, Your Honor.
All right, 212, no subs, right?
212, correct.
So ordered.
Thank you, Judge. And is anything coming?
And that was two case numbers, correct?
That's correct, Judge. It's
1,700 and 799?
correct, and it's at 23 CF 1700 and 24 CF 799.
All right, thank you.
Yep. You're welcome, Mr. Smith.
Thank you, John.
Good day, sir.
Derek McLean.
Your Honor, we have Mr. Derek McLean. Your Honor, at this time, I'm going to ask, well, actually, one moment, I'm sorry. Let me. Your Honor, we may be able to resolve this. The state gave me an answer on my last email about this.
What is the last?
If you would consider giving him 6 months of probation. Or if they gave an offer him 6 months, you need to. Or not offer, that's what. He got arrested in Alabama.
Just in the last year. I'll do it this time, but if he comes back, I don't even care if it's for walking with 2 left feet. I'm gonna ask for prison.
Okay, we're gonna be able to do that. So I'll call you back out. I got to do a plea form. Okay? All right.
Your Honor, this is going to be resolved today. I'm just going to need time to get the plea form together.
All right, very good.
All right.
Eric McQueen?
All right, Your Honor, I have Mr. Eric McQueen, case number 23 CF 2097. Your Honor, I'm going to ask to continue this. My client is getting screened for treatment.
So how much time do you want to continue it?
1 second, I'm sorry. At least 2 weeks, Your Honor. That should give Keaton House, it's Keaton House, they've been going pretty quick, so I can get the application.
Keaton?
Yes, Your Honor.
So 212,
Yes, Your Honor.
no subs?
No subs.
Okay. All right, 212, no subs, and of course, if you get the review sooner, you can advance it on any time so we can move the case forward.
Yes, Your Honor.
Okay, thank you.
Next, we have Willie Jackson III. Mr. McKinney.
Do you have a chance to read that through? Judge, this is Mr. Willie Jackson III before the court in 19 CF 1243. This is a violation of probation. We have reached an agreement.
All right.
The agreement calls for an admission to the violation of probation, adjudication of guilt. Previously, there was a withhold of adjudication in this case. 6 months in the Okaloosa County Jail with credit for time served. Part of the addendum is that he was arrested for new charges in Louisiana. The state has agreed that he will get credit going back to the date of that arrest as part of this agreement in this case. which would be the July 29th, 2025. So that would be with an additional $100 VOP, $150 cost of defense, and that will revoke and terminate his probation here. Those charges are still pending in Louisiana.
Okay.
May I approach with the plea agreement?
Granted.
No objections to the score sheet, which reflects 42.2 points.
Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, you can put your hand down. You heard what Mr. McKinney said and you signed the written plea form?
Yes.
You understand by this agreement that you're admitting the violation?
Yes.
That says to me, yep, I violated just the way the affidavit report says I did.
Yes.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove the violation?
Yes.
And in this case, you'll be adjudicated guilty if not previously. You'll get credit for time served, including the out-of-state credit from 7/29 to 25. You'll have additional fees and costs that were announced, and your probation will be revoked and terminated. Is a year enough time to get your fees and costs paid?
Yes.
Mr. McKinney answered all your questions about the plea and how it affects you?
Yes.
Satisfied what he's done for you?
Yes.
Court will find the plea to be freely and voluntarily entered into and will accept the plea.
Thank you.
Thank you, Judge.
And I'm going to have to take just a real quick break, real quick.
All right.
Saturday from 7 a.m. to 4 p.m. Serving lunch from 11 to 2. Hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke.
This will be Glenn Smith. With Scott Smith.
Judge, this is Mr. Flynn Smith. 2 case numbers, 22 CF 962, 22 CF 1956, Your Honor.
All right.
Yes, Judge, I spoke with Mr. Little.
And I'm sorry, I have the 962, what's the other case number?
It's same thing, it's 22 CF, but 1956.
195, do you have that one, Madam Clerk? Okay. And that's the reason we're doing this, not only the court reporter, but just to be sure we got everybody.
Absolutely.
No, it's not set for today.
When is it set?
Correct, all VOPs. I did send an unopposed motion in order yesterday, but I don't believe it got pushed yet. It is. Good.
1956 should be set for today. Last court date, they were both set together, so it should be tracking together.
Okay. We'll
Yes.
resolve that.
Excellent,
All
Judge.
right, so,
Today, I'm requesting to set this for the February 12th at 9 o'clock. I spoke with the State Attorney, Mr. Little, yesterday. He has no objection. From last court date, I got my client accepted into Keaton. I'm requesting that continuance because Ms. Dana Claw unfortunately could not be here today. She unfortunately is a victim to one of the COVID superbugs over at the jail, so she could not make it with the sickness. So I'm asking for that continuance so she can testify on February 12th.
all right. And so it'll be sentencing is what we're saying on February 12th?
Correct, Judge. Correct, plea to the bench and then the sentencing, Your Honor.
Okay. So 2 o'clock on 2/12.
It's 2 o'clock? Okay.
Yep.
It'll be 2 o'clock? Excellent.
Yes.
Just gonna make sure the state attorney's aware of that, but yeah. So February 12th, 2 o'clock.
Thank you.
We'll talk privately.
Thanks.
Yep.
Thank you, Judge.
Thank you now.
Next, we have Casey Nelson. Casey Nelson.
It's gonna be me.
So if I have one moment, Your Honor.
Yes, sir. Yes, it appears that you were appointed at first appearance and it just didn't make it through the system.
Yes, Your Honor. And in my system, he just got put in my system a couple weeks ago, right before the holidays. But I've spoken to the state. We're not going to be able to do anything today. We denied, if it hasn't already been denied. And state, how long do you need?
Just do 212.
You said it for 212. State has to speak to the victim.
State needs to speak to the victim.
Yes, Your Honor, just in the underlying charge was. and if we
Okay.
come up- we come up with
212 it
something
is.
for that.
It wasn't a new arrest. What new arrest? What are you talking about?
It's a felony battery.
Yeah.
Yeah.
I don't have no new arrest. I have a resisting arrest without violence, but it was,
I'm talking about the underlying charge.
I did a 12-1 prison sentence on it.
But he still needs to talk to the, because it's a violation, still has to talk to the victim. He has a constitutional obligation to do that. So we'd ask for the 212. If we come up to your resolution before that, Your Honor, we'll advance it on the docket.
Very good.
So if we come up with
Next will be Carter or Spain. Spain?
All right. You're here today without an attorney. Do you want an attorney to help you?
I thought my attorney was Thomas Koch.
I think it may have been his attorney before the VOP happened, Your Honor.
Well, I think it was Miss Merrifield, right?
Yes, sir.
Before the VOP.
I got a public defender letter whenever.
Yeah, hold on. Let's just double check and see where we are there.
I'm Thomas Koch. We're going to straighten this out this morning.
I don't see the first appearance paperwork, do you?
No, it looks like there's a notice too. Yeah, I don't know if he has a new case pending or.
Do you have a new case, another case other than this one?
Yes, sir.
Okay, what, do you know where, is it a misdemeanor or another felony? Do you know?
Judge, I may assist here. I have I believe is this the new law, 25 CF 2421.
Okay.
And in my system, I'm appointed to that 2421, but I don't have any VOP on my end.
All right, you're appointed in this VOP.
Okay. I know this is Mr. Snell's case. Is there any notes indicating possible resolution? I do see they filed on that new law case. I'm looking at the information.
When is that set, Mr. Koch?
I'm seeing that for today at 1:30.
So that's arraignment today at 1:30.
Correct on that new law.
Yes, it is. Go ahead and take care of that now.
Information has not been filed.
No information has been filed as of this time.
On my end, Your Honor, I just see that information has been filed this morning at 10:46.
Thank you.
Do you have a copy?
Just on my computer. I can make a copy or approach Madam Clerk or send an email.
That's not directed at you, you know that.
Absolutely, Judge.
Can you do that, Madam Clerk? Well, we can't print in this courtroom, so. Are you comfortable with doing the arraignment and printing a copy and giving it to the bailiff to hand to your client before
Absolutely.
he leaves the detention area?
Absolutely.
All right.
I'll print it out and this is the copy. This is the new law that I've been appointed to. And I also got appointed today to that VOP. I asked if there was a current offer. I don't believe there's a current offer on the table for both cases. So this morning, I'm going to enter a not guilty, waive formal reading. This is that new charge.
Thomas, if you wanted to plead today, I would do adjudication of guilt, 6 months in the Okaloosa County Jail, revoke and terminate all supervision.
And that includes
both cases.
Okay. Judge, if I just have a brief moment.
Absolutely.
Thank you for that additional time, Judge. We'll also enter a denial on the VOP. And if we can have this set on the 212 docket.
Do you want
I'm sorry, Judge, if we put it on the 3-9 together. But I can always bring you in sooner if we get a resolution. But we're going to put both cases on the March 9th docket. But I can always bring you to court next week, if we get a resolution.
All right. Set on 3-9, denials entered, not guilties entered, and you'll get a copy of the information to give to him before he leaves detention.
Yep, absolutely.
All right, very good. Thank you.
Follow that deputy, and I got that. McKinney's getting that printer.
Next we have Tristan Oja.
One second, Your Honor. Your Honor, today my client will be entering an admission. Now, this is case number 25 CF 1065. Your Honor, we're going to be entering an admission in exchange. For the admission, it's going to be an adjudicate guilt, revoke and terminate, 6 months, Okaloosa County Jail, with credit for time spent in Walton County Jail, cost prosecution, cost of defense. You get credit for all time, sir. Your Honor, I have a signed plea form if I may approach.
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I swear under, yes, sir, I swear.
Do you, okay, you put your hand down. You heard what Mr. Cochran said, you signed the written plea form.
Yes, sir. Yes,
You
sir.
understand you're admitting the violation.
Yes, sir.
That tells me, Judge, I violated just the way the affidavit report says it did. Is that what you're saying?
Yes, sir.
All
Sorry.
right. Do you understand that by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
And you'll be adjudicated guilty if you weren't previously. You'll be sentenced to 6 months in the county jail with credit for all time spent in the Walton County Jail. with the additional fees and costs that were discussed. How much time do you think you'll need to pay those things once you're released? Is a year enough time?
2 years, sorry.
2 years to pay?
Yeah, I was on
All right.
administrative leave from my work. I don't think I'll be able to go back, so, yes, sir.
Okay. All right. 2 years to pay. Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir, he was great. Yes, sir.
And I'll accept the plea as freely and voluntarily entered into. Thank you.
Thank you, sir. You have a
All right.
blessed
Good
one.
day.
This way, sir. Next, you Kelly Midget.
Your Honor, we have Miss Kelly Midget, case number 22CF2562. Your Honor, this morning we're going to deny the violation, but I would like to speak to Mr. Gomez.
There he is.
If we can call her in back in a few minutes, Your Honor. Your Honor, I'd ask to set this for 2/12. My client has a new law that is set for 2/3.
For arraignment?
It's a misdemeanor. Sorry, Your Honor.
Okay.
But there's a victim and those things go into consideration.
All right, so a denial, well, previously it was denied, so we'll set it for 2/12.
Yes, Your Honor.
Okay, very good. No subs, I'm guessing.
Yes, Your Honor. No subs.
That's why we're on probation. Judge, this is Ms. Beth Parsons. I have two case numbers, 25 CF 96 and 24 CF 2506. If I may have a brief moment for a signature.
Yes.
Judge, Ms. Parsons will be admitted to the violations this morning. This is going to be maintain the withhold of adjudication with the omission, reinstate all original conditions and all original costs, modify to add restitution in the amount of $834.50 to Kurt Schaller. There's a $200 VOP cost prosecution, $250 defense costs, all counts and cases that run concurrent. If I may approach with a signed plea form and a score sheet.
Granted. All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
You can put your hand down. Now, you heard what Mr. Cochran said, Mr. Koch said and signed the written plea form.
Yes, Your Honor.
And you understand by this plea arrangement that you're admitting the violation.
Yes, Your Honor.
Now, it says to me, yes, I violated just the way that affidavit report says it did.
Yes, Your Honor.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, Your Honor.
Adjudication will continue to be withheld. All the original conditions will be reinstated, modify to add the restitution, and you'll have the additional fees and costs that which were announced. Is that your agreement?
Yes, Your Honor.
Mr. Koch answered all your questions about the plea and how it affects you.
Yes, Your Honor.
Satisfied with what he's done for you.
Yes, Your Honor.
Court will find the plea to be freely and voluntarily entered into and will accept the plea.
Correct. Set. Slide that way. Follow the deputy.
And we have Sierra Sawyer with Mr. Contreras.
Do you need to speak for your patients? Nope, okay, just want to make sure. Sorry. Judge, this is Ms. Sierra Sawyer, 25 CF 2242. If I may have a brief moment. Thank you, Judge, for that additional time.
You're welcome, sir.
Judge, this is, and thank you for accommodating and putting Ms. Sawyer on today's docket. Mr. Snell did speak with the alleged victim, and he has agreed to the PTI, pretrial intervention agreement. So I was informed my client that Mr. Snell has no objection to ROR her today in the court's minutes. She will be released. She has contact information to go down to probation down at Fort Walton Beach. I said most likely tomorrow by the time she gets out and gets a ride, and she will take this signed contract and enter the program.
All right.
I can sign it right now.
She can sign into it right now, even better. You know what, I forgot this morning. Could you stay there for 1 second?
Thank you, Your Honor.
Excellent. Thank you.
Right. Okay.
I'll do that right now, then I'm gonna give it to the clerk. And I'm gonna tell her to still reach out to you tomorrow, just to get a game plan. Oh, even better. Perfect. I'll have her sign it. Okay, thank you. Perfect. So switch the game plan. We can enter right now because probation's right behind us, so you can sign it right there. And it's 1:15:26. And you keep your copy I gave you, and after we present this to the court, you're gonna briefly speak probations, but you don't need to go down there to sign it in because now you're gonna be officially in. If I may approach you, Your Honor?
Granted.
All parties have signed.
Very good. All right, so that makes the bond moot.
Correct, Judge.
Okay. All right, very good. Thank you.
Your Honor.
All right, best of luck, and you got my card, but still come talk to me about that key.
Yes, I'm going to tomorrow.
Excellent, you're welcome.
All right, and I think we have Mr. McLean with Mr. Cochran, and I have Julissa Thornton with Mr. McKinney.
I do, Judge. I have Julissa Thornton. We had set this as a status for payment.
Yes.
May I approach with Mr. Gomez?
Yes. Also have Robert Mathias, Mr. Cochran.
Your Honor, I believe that case is pled out.
That's why that rang a bell for some reason, but.
Yeah, I believe he pled out previously. He's closed in my system.
Yeah, okay. Do you show that, Madam Clerk?
Yes and no. So
Yes and no.
This is a CT case that is set for today, and information was never filed on that case, so it pled, but it didn't plead. I mean, it pled.
In the old days, when we were actually having paperwork, we would say no job is finished till the paperwork's done, but I guess now it's no job's finished till the pixels are completed. So if there was no information on the CT, then we can't actually plead to it, right?
Okay, so you just need to make sure the information is filed on the, he's already pled to it, right? He pled to it the day we did this. That's what I thought.
So it's the CT, 25 CT 901.
The CT is the DUI, correct? DUI, the citation can act as the information.
I don't have access to my email, but we've corresponded with the state regarding citation, everything, according to our supervisor, we have to have the information.
All right. I mean, I thought technically the citation is a charging document, but I understand it's not the clerk's fault.
Say, according to our manager, she specifically stated the citation is not the charging document to run in the file.
That's so frustrating. I hear you, but she doesn't dictate the laws, unfortunately. I mean, this is one of those situations, Judge, where it's like the clerk holds everybody's feet to the fire. I'm not saying it to you guys, but they're holding their feet to the fire. Legally, this case is closed out. We've pled it out. There's a charging document with the citation in the file. That's, respectfully, with all due respect, that's on the clerk's side to manage their system. And they can't make up laws and then hold our feet to the fire when legally we have a charging document in the file with via citation, a misdemeanor citation.
Your Honor, I would ask me to address this at the end of the day. Maybe I can go contact the clerk myself and see if we can work this out, and we'll just bring it back up.
So ordered. All right, so that leaves us with Mr. McLean, right?
Yes, sir.
Yes, Your Honor.
And he's in the seat, he would like to have a word with the attorney.
All right. Step into the feed, Mr. Cochran.
That is not directed at you guys. I know it's not on you guys at all.
No, we don't need him. He could release him, or, thank you. That should be all set till 2:30, 12:30.
Yeah, we're ready.
This line, and then date, right?
One moment, Your Honor. You get a signature from the state. There's one quick change, I just tell my client.
Okay, so.
All right, Your Honor, we have Mr. Derek McLean, case number 22 CF 1059. Your Honor, today we're going to enter an admission to the violation. In exchange for the admission, state has agreed to modify and add 6 months of community control, followed by the remainder of standard probation. Court costs, no other penalties.
All right.
And his previous costs of supervision were waived. We'd ask that that be maintained. If I may approach with the plea form and the score sheet.
Granted. Raise your right hand, please. Do you swear affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. Can you put your hand down? You heard what Mr. Cochran said on your behalf, and you signed the written plea form?
Yes, sir.
Do you understand by this plea arrangement that you're admitting the violation?
Yes, sir.
And that says to me that you agree that you violated just the way the affidavit report says you did.
Yes, sir.
And by doing this, you understand you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
In this case, your sentence would be a modification to add 6 months of probation,
6 months community control.
6 months of community control starting now,
Yes, Your Honor.
and the regular termination date. So there's not an additional 6
No,
months.
it's to add 6 months. There is an additional 6 months.
So his termination date is extended by 6 months.
Yes, Your Honor.
And the first 6 months after he's released is on community control.
Yes, Your Honor.
Okay. Is that what you understood?
Yes, sir.
Okay. And you'll have the cost of prosecution and the cost of defense added, and the court will continue to waive the cost of prosecution. Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
You satisfy what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Now, other than that disputation on Matthias, are we ready to roll? We're all done?
Just with the exception of violation, which, is it clean into drug court as far as you know?
Yes. My understanding is that Judge Ward admitted Diane Wiley into drug court yesterday. Is that right?
My understanding is that got moved to next Wednesday for entry of the plea next week.
Okay. All right. All right, so we'll just keep track. If it needs, Judge Ward will move it back to our docket if need be.
I believe that's definitely coming into my next week. So
All right. We'll see you at 12:30.
So she just forwarded the last correspondence, so you guys can go for the contact.
This is injured. Take a breath. Call Coy.
You prepared, Madam Clerk?
Okay. Oh, thank you. Thank you.
And Ms. Beckman, you got the email regarding Martin.
Yes, Your Honor, I did. Would you like myself and defense to contact the court team?
Yes, to reschedule.
And I know Mr. Davis was wondering if you would like him to still appear this afternoon or not.
Say again?
Mr. Davis was sending an email to Ms. Natali wondering if you still needed him to appear this afternoon.
No.
Okay, thank you.
Excellent. Judge, this is Mr. Roscario in 25 CF 2429. I have acknowledgement of a 21 count information. We'll be entering not guilty all counts, waive formal reading, and request this be kept on the March 9th pretrial docket.
So ordered.
Thank you.
I have one more. That's an arraignment. We got one more of the DPS director, Your Honor, one more couple.
All right.
Last name Montoya.
It's Luis Montoya, 25 CF 2405. Your Honor, we have Mr. Luis Montoya, case number 25 CF 2405. We have receipt of the information. We'll waive formal reading, enter a plea of not guilty. The state has made an offer of 4 years probation with 48 hours community service. But I would want my client to know he does have an ICE hold. And if he took the plea, he would likely go into ICE custody.
Well, on the bottom of that offer, I wrote, that's where my head is at. I need to speak with the victims and as well try to assess any potential restitution from the 2 vehicles before extending a formal offer. I just wanted to give them an idea of where my head is at. I know count 1 actually requires an adjudication of guilt and then a year of a driver's license suspension under the statute, so that would be a part of it. There's also a DUI and a CT case that should be with ours. And so we are trying to get that transferred up so I can handle both cases.
So we'll ask to continue this, Your Honor, to the February 12th court date?
3/9, so please.
Oh, yeah, I'm sorry, 3/9.
All right, so ordered.
Thank you, Your Honor. Thank you.
And on the 12:30 docket, Teams was previously continued, correct?
That's correct, Judge.
All right, who's next on the PTD docket? State?
I'd be good with Christopher Mestis.
Right, Christopher Mestis, number 2, Christopher Mestis.
Dude, we enjoyed Mr. Rogers' vibe, for sure.
Yeah.
Your Honor.
David.
Yes, Your Honor, at this time, the state is not moving for pretrial detention. We'd be looking to make arguments for bond. I don't know if you want to have defense go first or myself.
Can you see anything else?
So the state is not moving forward with their motion?
Correct, Your Honor.
They haven't filed a formal charge yet, so they don't have one for today.
One moment, Your Honor. I'm ready, Your Honor. If I may take some testimony from my client.
Raise your right hand, sir. You swear affirm testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, Mr. Mestis, if you're granted a lower bond that you can afford, where would you live?
At my house at 53 Robies.
Okay. And who lives there with you?
My wife.
And do you take care of your wife and your home expenses?
Yeah, mutual.
Okay. Do you have any dependents?
I do not.
If you're released from jail, would you be able to regain your employment?
Absolutely.
I believe that's all the questions I have, Your Honor.
How long can I ask?
Oh.
So where is he going to live?
At his home address, Your Honor, which is
53 Robies, apartment 2.
All right, because the reason I ask that is because the identifiable probable cause indicates that he's not housed.
there must be a mistake on.
I've been in Mary Esther at 53 Robies for 5 years.
Who's your landlord?
It's through Rock and Bowl LLC.
Okay.
And I forgot to ask, I'm sure this is probably the question the state was going to ask, how long have you Have you lived in this area?
My whole life. I was born and raised here.
Are you good with your questions? Have you ever lived in Colorado?
Yes, sir.
Have you ever lived in Texas?
No, sir.
Have you ever gotten arrested in Texas?
Yes, sir.
I have no further questions.
No further questions, Your Honor.
Arguments?
Yes, Your Honor. Your Honor, I'd ask for $25,000 bond on each count. There's no way my client could ever touch a $150,000 bond. Even the 25 on each count would be a stretch to possibly make that. But that would be our request, Your Honor, at this time.
Okay.
Your Honor, the state is requesting in total $152,500 cash professional bond. 100,000 of that would be on count 1, 50,000 of that would be on count 2, 2,500 of that would be on count 3, and then 4, 5, and 6 would all be RORs. When requesting this bond, we are looking at the factors in 907046. Namely, we're looking at the FTA that the defendant had in 2018. In 2022, he was actually arrested in Okaloosa County as a fugitive of justice from Colorado. He has convictions in Colorado, Texas, and Florida. In this particular situation, we are looking at a case where he had a pouch on his person. Inside that pouch was 5.5 grams of suspected fentanyl, 25.4 grams of suspected meth, and then also a small amount of cocaine. We feel like, given the defendant's prior criminal history, both are in 3 different states, a fugitive of justice arrest that he had in this state for Colorado, a failure to appear, the fact that in the addendum of probable cause it actually stated that he was fleeing from law enforcement, we feel as though there is a heavy risk of fleeing here, and we feel like a bond should reflect that. So under the factors of 907046, the information in the addendum of probable cause, we would respectfully request that $152,500 cash professional bond for these charges, Your Honor.
Mr. Cochran.
Yes, Your Honor. I understand the client's history. My client's entitled to a reasonable bond, Your Honor, and I understand the state's position that there's no possible way my client could ever touch that. I would ask for 25 on counts 1 and 2, ROR on the rest of the counts. My client has the ability to make the court dates. He has support. He has long history and connection to the area. I understand he's been out of the state at some times through his life. For the majority of his life, he's been a Florida resident, and specifically to this area. So we'd ask that the court give us a reasonable bond that he could possibly touch. I'm sorry, I said 25 for each count? Yes.
And the state does agree there's no PC on count 6, right?
That's correct, Your Honor.
Okay. Well, after hearing the arguments, considering the PC and the 903046 factors, the court does find that no PC on count 6, RO on count 5, RO on count 4, 5,000 on count 3, 50,000 on count 2, and 100,000 on count 1. Here we have 25.4 grams of meth, 2.4 grams of cocaine, and 5.5 grams of fentanyl. The court finds those bonds under the circumstances presented in the 903046 factors to be appropriate. The defendant will be placed on pretrial services weekly reporting in person, surrender all weapons and firearms, GPS monitoring $2 a day, and otherwise the standard pretrial conditions.
Thank you, Your Honor.
Charles, who are you calling next?
Whoever you want.
Can we do Tyrell Marshall? Just gonna be,
Frank, give me Tyrell Marshall.
and then we can do Morton after that.
Who's that?
Morton, those are gonna be two quick ones.
Okay.
These two are gonna be continuances. We just got the full report from Marshall, because the full beach officer who wrote it wasn't even the one who investigated the crime. So.
How are you doing today, sir?
Morning, Your Honor. This afternoon, Your Honor, we have Mr. Tyrell Marshall, case numbers 25 CF 1982 and 26 CF 0120. 25 1980. Your Honor, I believe the state's going to ask for a bond
No,
on 26.
we're gonna be requesting a
Or
continuance,
continuance,
Your
I'm
Honor,
sorry.
on this. We reached out, so we get the arrest report, we immediately try to reach out. The officer who wrote the arrest report was simply the first officer on scene. He didn't actually investigate anything. And so we've already reached out to the investigator who investigated it, to have him be able to appear next Thursday. So we would request a continuance to next Thursday at 12:30, Your Honor. And then we will also be getting a written motion filed within the next 12 hours. I say that, give me 18.
Mr. Carr.
Your Honor, the state's entitled to one continuance based on good cause. Not having an officer, I guess, is good cause.
All right, matter will be continued to 1/22/26 at 12:30 Central.
Thank you, Your Honor.
So we don't.
Morton, Jr.
Your Honor, we've got Mr. Tommy Morton, case number 260131.
Your Honor, the state is going to be requesting continuance on this as well. We got this case while I was in inmate pretrial yesterday, so I haven't had a full opportunity to go through it. I would respectfully request that this also be continued until 1/22, and if I review the case and find that we can maybe agree on a bond, I'll get with Mr. Cochran, and we will make sure that gets done before that Thursday date, Your Honor.
Frank, look at the Rogers and Fee, consider it Rogers and Fee.
All right, matters continued to 1/22/26 at 12:30 PM Central.
Thank you, Your Honor.
Judge, this is Mr. Cedric Rogers, and we're here, case number 2026 CF 103.
Yes.
It's my understanding, speaking with Mr. Snell, they're not moving forward with the pretrial detention hearing this afternoon.
God bless you. Is that right?
Yes, sir, that's correct. Mr. Rogers wasn't arrested that night for a crime listed in the dangerous crime statute there. We're asking the court to set a bond today.
All right. Arguments on the bond?
Yes, Your Honor, I'll find my little sheet of paper here with me. I believe Mr. Rogers was arrested for false imprisonment, battery, and petty theft. Although those charges aren't in the 907041 list, this situation was a very serious event that happened. The victim was taken to a hotel room and demanded payment for $100 and was not allowed to leave the hotel room without paying the $100 to Mr. Rogers. The co-defendant demanded payment in the hotel room, and when the victim was not able to make the payment, then there was an assault and a battery. The whole event started to take place where the victim was beat up, eventually hit in the head with a firearm with the butt of a 9mm. There were witnesses that heard the victim crying out for help. She attempted to make an escape to the door. She was prevented from leaving the room by Mr. Rogers, who stood in the doorway, and it was made clear that she wasn't leaving until he had his $100. The victim's brother was contacted with pictures of the condition of the victim and demanding $100 payment. It's just it's a terrible whole scenario and a horrifying event for the victim. Eventually, the victim's brother was able to cash app $100, which secured his sister's release, and her belongings were, she wasn't permitted by the co-defendant or Mr. Rogers from getting her personal belongings from the hotel room afterwards. They pawned a laptop and some other things that she wasn't permitted to go back into the room. She had a significant head injury from being hit in the head. There was a time when she was crying out for help that a pillow was placed on her face and hands over her mouth to keep people from being able to hear her cry for help. It's just a terrible situation. The state would ask for $500,000 on the false imprisonment, $15,000 on each of count 2 and 3.
Mr. Koch.
Judge, may I have a brief moment, please?
Yes.
Judge, before I make an argument, may I have some brief testimony from my client?
Raise your right hand. You swear affirm testify truthfully in this matter under penalties of perjury.
Yes, sir.
Thank you, Judge. Can you please state your full name for the record?
Cedric Lee Rogers,
If released, where would you reside at? Where would you live?
313 Hollywood, Northwest Hollywood Boulevard.
Is that in Fort Walton Beach?
Yes, sir.
Okay. How long have you lived there?
Lived there for like 15 years or probably a little over.
You lived there for 15 years in Fort Walton. Who lives with you at that address?
My great-grandma, well, my grandma, my mom, my little brothers, and my kids.
Great-grandma, your mom. You said some little brothers you have? How many?
2.
You have 2 brothers. And you said you have a child?
Yes, sir.
1 child? How old is that child?
He's like 2 months.
2 months old. Okay. Do you have a job if you get released?
Yes, sir.
Where do you work at?
I do concrete.
You do concrete work. How long have you been doing that?
I've been doing that ever since I was like 13, 14.
Do you work for a company?
My granddad's company.
Your grandfather's company? Does that company have a name?
Oh, Willie Sheffield's Concrete.
Willie Sheffield's Concrete, okay. Now, in a moment, I'm going to ask the judge for a bond. I'm also going to ask for an ankle monitor to be placed on you. Would you abide by that?
Yes, sir.
Okay. And any pretrial service conditions, you'd abide by any court order?
Anything you want me to do?
Anything you want us to do, okay. Thank you, Judge. I'll make an argument.
Any questions, State?
No follow-up, Your Honor.
Yes, Your Honor. Defense respectfully is going to request $50,000 cash professional for count 1, the kidnap, false imprisonment. It's a F3. Asking for $2,500 for count 2, battery, first-degree misdemeanor, and asking for $2,500 for count 3, petty theft, first-degree misdemeanor. Will also comply with all pretrial release services that's imposed by this court. Weekly in-person check-ins, also for an ankle monitor to be placed on my client. Also, for pretrial supervision, of course, no contact with the alleged victim, no contact with any co-defendants, and no contact with any of the witnesses involved in this case, Your Honor. My client has lived in Fort Walton Beach at the same address for 15 years. Grandmother, mom, he has 2 brothers, and he has a child that's 2 months old. He does have employment. If released, and he said he was in the concrete business. He stayed since he was 13. Willie Sheffield's Concrete, and of course, I'm a public defender. He is indigent, so I'm asking for a reasonable bond, Your Honor, respectfully. So totals the amount of $55,000 cash professional, Your Honor.
All right. Any follow-up, State?
No, sir. I would ask for weekly in-person reporting to pretrial services, and I agree with the ankle monitor and no contact with the victim in the case or family or any place, not to go anywhere where she frequents or where she lives or works. So.
All right, place the defendant on pretrial services, no contact with the victim, not be at or about any place the victim may be. Surrender all firearms and weapons to the sheriff's office, GPS monitor, $2 a day. Follow all the rules, all the standard rules, report in person for Long Beach pretrial services. I've read the substantial addendum probable cause and the findings of the pretrial. On the petty theft, it's $2,500. On the battery cause great bodily harm, cause bodily harms can be $50,000, and given the facts and circumstances alleged, the court does find a $500,000 bond is appropriate under the circumstances for count one.
Eric Phillips.
Judge, this is Mr. Eric Silvas in 2026 CF 21.
The state, Your Honor, is seeking pretrial detention in this matter.
All right, you may proceed.
Judge, if I could call Deputy Hennis.
Raise your right hand, please. Madam Clerk, swear the witness.
Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Please be seated. Direct your voice to the microphone you see in front of you. Speak clearly and distinctly so we can all hear and understand you. Also, the reporter in the back of the courthouse is trying to make a record, so it's important they're able to understand you. If any one of the lawyers objects, stop speaking immediately until you receive an instruction on how to proceed. Is that okay?
Yes, sir.
All right. You may inquire.
Sir, if you could please state your name for the record.
Timothy Hennis.
What is it that you do for a living?
I'm a deputy sheriff with the Okaloosa County Sheriff's Office.
And were you employed on January the 1st of this year?
I was.
Were you on duty that day?
I was.
Did you have any reason to have any contact with the defendant, Mr. Eric Silvas?
Yes, I did.
Can you describe for the court what that contact was?
Absolutely. So the morning hours of January 1st, we received a call for a burglary in progress at the Chesalon Apartments on Racetrack. We got information that a subject was kicking indoors forcibly. I arrived on scene. I was the first deputy to arrive on scene. Made contact with Mr. Silvas, who was actively trying to kick in a door. He had also kicked in a separate door. Made contact with him, ordered him to show me his hands. He declined and said that made a comment that he was trying to kill somebody.
So you pull into the apartments. Did you have any idea where you were going when you got there?
Rough idea. We knew that it was going to be, the caller was in 3308 and that Mr. Silvas had forcibly entered 3307.
So the caller, what did they describe has happened? What did they see?
They stated they saw a male kicking in a door. They stated they watched him go inside, walk around for a little bit. As I was arriving on scene on the first floor of the building, the caller actually called back and stated that the subject was attempting to kick in a second door. About that time, I heard the kicking coming from the area of the third floor. Arrived on the third floor and made contact with Mr. Silvas.
So you drive in, you get to the location, you open the door, and what did you see or hear when you stepped out of your cruiser?
As I was walking up, I didn't hear anything. I was, trying to determine if he had fled the scene or not. Then at that point was when we received the call that he was trying to kick in another door, and I heard the thud consistent with somebody trying to kick in a door.
Okay, so you hear the thud, and then what'd you do?
Got on the elevator, went up to the 3rd floor, walked around the corner. I observed Mr. Silvas in front of unit 3309 standing there. And then I also saw unit 3307 had been breached.
Okay, so you come around the corner, you off the elevator, come around the corner, and you see him, and then what did you say to him?
I ordered him to show me his hands. Due to the circumstances, I had my agency weapon drawn. Ordered him to show me his hands, and he made the statement that he was there to kill somebody. Then I began giving him commands which he was not compliant with. He began reaching around in his bag, began trying to reach in his pocket. Once he finally was compliant and down on his knees in a position, I waited for my backup and then took Mr. Silvas into custody, or attempted to.
How long did you have to wait for backup?
Between initial contact, I think it was roughly a minute and a half.
Okay, so pretty, well, that might have felt like an eternity, but.
Yes.
Okay. When he refused to obey your command to stop what he was doing or put his things down, and then when he actually came into compliance, how long of a period of time was that?
I couldn't say less than a minute, closer between 30 seconds and a minute maybe.
Okay. And did he make any further statements or movements or anything once he, I guess, would you say you had him kneel down? Is that what?
Yes, I had him kneel down in front of me, waited until additional officers arrived on scene because I didn't know what the circumstances were. Then at that point, we moved in to take him into custody.
Okay. Now, you made the comment that said he was there to kill somebody. Did he tell you who he was going to kill?
He stated that someone had kidnapped his brother and that he was there to kill the person for kidnapping his brother.
Okay. The apartment that the door was open and broken, was anybody home there?
Not at the time that he breached it, no.
Do you know if he went in that apartment?
The information that we received, yes, and also Mr. Silvas was found in possession of stolen items from within the unit that was breached.
The witness, did you get anything, any indication how long he might have been in that apartment?
I couldn't tell you. Between the 911 call and initial contact, I'm not sure exactly what or how long the witness had seen him inside of the unit.
So things that he was found that he had on his, I guess he had them in his pockets or on in his hands or something?
In his possession, between either in his pockets or in his hands, and then also in the bag that was next to him when I made original contact with him.
Okay. Did those items give you any indication of what he was doing inside the home or the apartment?
Not specifically. It was a set of keys and alcohol. So we aren't sure what his motive was for getting inside.
Were the keys, do you think they were the keys to the unit?
I believe they were, yes. I believe at least one of the sets of keys were to the unit of the one that he had forcibly breached.
Okay. And then the second unit, did you actually see him kicking the door?
No, I didn't.
Okay, but you heard him?
Yes.
Okay. Did that door ever get breached? Did it ever get opened?
The second door?
Second door.
No, it did not.
Okay. Is there any characteristic about the first door that was broken in that is relevant or pertinent that you think?
It was deadbolted lock.
Okay. So the deadbolt, it had to have been kicked hard enough to where I guess it broke the wood framing of the door to get in, is that?
Yes, the deadbolt was still engaged at the time that we arrived on scene. So it was strong enough to kick through the door to breach a deadbolt door.
Okay.
Well, let's pick up then when backup arrived. What happened once other deputies arrived?
Once other deputies arrived, moved in to, place Mr. Silvis into hand restraints. He began crawling forward on his knees from the position that I had him in originally. Once I had him down on his stomach, he pulled his right arm away from me. His right arm at the time then began reaching towards his front right pocket, where we later discovered a welded open knife.
But you're actively trying to get his arms behind him to handcuff him, and he's pulling away with the right arm to get to the pocket.
Yes, I had control of, I had initial control of both of his arms, and he pulled his right arm away from me and reached in the area of his front right pocket.
Was he saying anything during this time period?
Not that I can recall.
And how many times did that occur? That he, like, you'd grab his arm and he'd try to go back to his pocket? Did that happen more than one time?
I believe it only happened once that I can recall. He reached down towards that area, and I reestablished control with his right arm and got it behind him, and then was able to have another deputy come assist me to get him into handcuffs.
Are there any initial thoughts about Mr. Silvis that night? What his condition, anything that's of note that the court should know? Your impression of him?
It seemed like he was on a mission to make entry and do harm to somebody. Whatever his thought process was, it seemed like the way he was acting, refusing commands, trying to walk away, approaching aggressively, the fact that he had already kicked in a door that was deadbolted locked and attempting to kick in a second one that was occupied by a younger female, it showed me that he was under the impression that he was going to go in there and commit harm to somebody else.
Judge, that's all the questions I have at this time.
Mr. Koch.
Yeah, Judge. Good afternoon, Deputy. So the 3308 department number, that's where the caller was calling from?
Yes.
Okay. Do you know that caller's name?
Not off the top of my head, no.
Now, when the caller called in, I guess I call it the bolo, you stated it was a male. Was there some more description on that bolo when that caller made that call?
I believe it was gray jacket or dark in colored pants or something along those lines. I'd have to go back and look at the original call.
So gray jacket and?
Dark in colored pants, or I'm not sure exactly what she had mentioned.
And that caller was in 3308, and it was in regards to the apartment number 3307?
Yes.
Okay. And I believe your testimony from Mr. Snell was that you physically, or you didn't observe anyone kick that door in on 3307?
No.
And that 3307, that apartment, that's the one that got breached, or the door was open, as you stated, correct?
Yes.
Now, the stolen items you stated that you found on my client, it was a set of keys and some alcohol.
Yes.
Okay. You said, I believe, one set of keys was to that unit, and that was referring to 3307. Did you physically check those keys to see if it is for that unit?
No, I did not.
So if you didn't check it, it could be for another unit or for another apartment, correct?
Possibly.
Okay. Now let's talk about the alcohol. Was it beer cans? Am I correct on?
Yes.
How many beer cans were there?
I think there was a total of 5 one was open, or one or two were open.
Okay. Through your investigation, how did you determine that the 5 beer cans were related to apartment 3307?
The owner of the unit arrived on scene and confirmed, took a look at the inventory that was located in the area, confirmed that those items came from within his fridge.
What type of beer cans were they?
I don't know the exact type.
Now, when beer cans are purchased together, you flip them upside down, and there's a serial number on them, and they all match, so you know it's from the same, 24 pack. Did you physically check those serial numbers?
No, I did not.
Now, as you stated, when you arrived, we're not in 3307 anymore, but you heard a thud, and that brought you to apartment number 3309, correct?
Yes.
You heard a thud, but did you physically see my client kick in the door?
No.
Okay. And as you stated, that 3309, that was never breached, that was just a thud or?
Correct.
Okay. Now, the knife that was recovered, how big of it, is it a pocket knife, or how long is the blade on that knife?
It's a normal pocket-sized knife, but it had appeared to be welded open on the back side of the blade to where it couldn't be closed.
Welded?
Some type of bonding agent to keep it from closing.
Okay. And I know you said standard, but when I think of standard, I'm thinking a couple inches of a blade for a pocket knife?
I would say roughly 3 inches, maybe.
3 inches. No further questions, Judge. Thank you.
Redirect.
Yes, sir. You said it was welded open, so it would be like almost like a dagger in a way, right? Like you
Almost simulating like a fixed blade knife.
Okay. The man that you saw when you got up there and heard the noise and saw him, that you ended up arresting, do you see him today here?
Yes, I do.
Could you describe him?
He's seated right there at that table wearing an orange jumpsuit.
And you mentioned the Ches Elon Apartments, that's in Okaloosa County?
Yes.
That's all the questions I have, Your Honor.
Is the witness released?
Yes, sir.
All right, you may step down.
This time, Your Honor, I'd like to call Sergeant Peterson.
Swear the witness, please.
Do you swear affirm the testimony you're about to give me the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
Thank you.
Please be seated, direct your voice to the microphone, speak clearly and distinctly so we can all hear and understand you. If one of the lawyers objects, stop speaking until you receive an instruction. Is that all right?
Yes, sir.
You may inquire.
If you could please tell us your name.
Cutler Peterson,
Sergeant Peterson, where do you work?
Okaloosa County Sheriff's Office.
Were you employed there on January 1st this year?
Yes, sir, I was.
Were you on duty that day?
Yes, sir.
Did you participate in the call out to the Ches Elon Apartments that night with involving Mr. Silvas?
Yes, sir, I did.
I guess tell us how you got called out, what brought you there, and then what did you observe when you got there?
We received a call for a burglary in progress. Of course, that requires a bunch of units to respond. I was on scene pulling up reference to that call, as most of my people were on scene establishing a perimeter and stuff.
Okay. So how did you know where to go when you pulled up?
The apartment numbers and the buildings are individually listed. That apartment was in the south left side, or I'm sorry, southeast side. Plus I've worked at in that zone and stuff for the past 12 years, so I know the area pretty well.
Okay, so when the dispatch is telling you the unit, in your mind, you knew where?
Yes, sir.
Okay. So you pull up and exit your vehicle, and what happened then?
As I pulled up, I heard Deputy Hennis call out that he had contact, knowing that the unit number was on the 3rd floor. I immediately ran up the stairs to assist Deputy Hennis.
Okay, and you got to the top of the stairs, what'd you see?
Once at the top of the stairs where I took, there was multiple corridors. That's a long hallway with apartments on both sides that are adjacent to each other. So I had to go through multiple hallways till I found contact with Deputy Hennis, where he was challenging Mr. Silvas at gunpoint.
Okay. Describe that.
Stressful is one word I would use. We've gotten a call for someone breaking in doors. Once you get on scene and you see Deputy Hennis is challenging Mr. Silvas, he's not being compliant. He's argumentative, cussing at us and saying obscenities, not complying with commands, reaching down for his backpack, reaching in his pockets and stuff. And for an unknown subject like that, where you don't know what they have on them, they could have a weapon or something. Once I got on scene and saw Deputy Hennis challenging, I also observed the unit of 3307 was kicked in. You could see damage where the door was busted open. Wood was laying on the floor and stuff. So I helped get compliance from Mr. Silvas and then held the door because we did not know if there was anyone else on scene.
What actually did you have to do to get him secured? What kind of help? Like what was
Due to the danger of that door being opened and unknown if anyone else was inside that residence, I held that door and provided a tactical shield for them using my body armor. Another deputy, Deputy Behrens and Deputy Simpson arrived on scene. I immediately ordered them to assist Deputy Hennis with taking him into custody because I could see Deputy Hennis was on the ground with Mr. Silvas, and Mr. Silvas was resisting. He was actually moving his right arm out from under and trying to go for his right pocket.
And you witnessed that as well?
Yes, sir, I did.
Okay. When you saw him doing that, what was your thought?
My immediate thought was he's probably going for a weapon, and that's when I immediately yelled at Deputy Simpson to help him.
Okay. And I asked Deputy Hennis earlier, how long did you feel like that interaction took place? I mean,
Mentally, it was an eternity, but in reality, I think it was about a minute and a half, 2 minutes tops.
okay. Was it you guys were able to overpower him, or did he get tired, or what did he just
Initially-
finally give up? What did he-
Initially, Deputy Hennis needed assistance, and once he got further officers on scene, they were able to get him in custody. At no point did he comply that he had to be forced into custody.
Okay. Now, did you ever talk to Mr. Silvas?
I did later on, post Miranda.
Okay. What did you learn in that interaction?
During that time, he admitted to me that he went into that apartment 3307 and took the beers and some house keys. I then went and saw the beers, observed them, that they matched the ones that were in the fridge in that apartment. The victim had stated he had approximately 10 or 11 beers left, and you could see that there were 5 missing from that count that he had. I then picked up the keys that he had said that he had took from the apartment, went, inserted them into the lock of 3307, and used it to deactivate the deadbolt, confirming that those keys belonged to that apartment.
Okay. Did the keys have a key chain or anything on it that would identify them, or was it just a ring?
Just a standard ring.
Okay. Did Mr. Silvas ever talk to you about why he was there and what he was doing, what his purpose was that night?
Not intentionally. I did hear him overstating that he was there to kill someone, and that it was reference to his brother, but I never directly spoke to him about any of that. Those were just statements he was making out loud in the hallway.
Was he saying he knew who he was trying to kill, or just
He did not seem like he had an intentional target, just a general scope.
So your impressions from him that night and the safety of that apartment complex?
I don't think anyone, if Mr. Silvas is out there, is going to be safe.
And, okay, that's all I have at this time, Judge.
Mr. Koch?
Your Honor, may I just have a brief moment?
Yes.
Thank you, Judge. No questions for this witness, Your Honor.
All right, so witness released.
Yes, sir.
Thank you.
Thank you, sir. If I could call Emmanuel Dominguez.
Raise your right hand, please, to receive the oath, Madam.
Do you swear from the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Please be seated and direct your voice to that microphone you see in front of you.
Yes, sir.
And speak clearly and distinctly for us, please.
Yes, sir.
If anyone objects, please stop speaking until you receive the instructions. Is that okay?
Yes, sir.
Okay. You may inquire.
Could you please tell us your name, sir?
Yeah, Emmanuel Dominguez.
On January the 1st, where did you live?
January 1st, I live at Ches Elin Apartments, Unit 3307.
Okay. Were you called to your residence at some point, notified you needed to come back to your residence that perhaps had been broken into?
Yes, sir. That morning, Sergeant Peterson called me.
Okay. When you arrived at your apartment, what did you find?
Oh, that my door was kicked in, sir.
Okay. Well, can you describe the condition of the door?
Oh, the door was kicked in. The lock was still, as they mentioned before, engaged, but the door was forcibly, kicked in. You could see the frame of the door was broken. And
Okay. Did you walk around and look around your apartment, I guess, at that time?
yes, I walked around along with the officers that was there on the scene.
Okay. What'd you notice in your apartment?
I just noticed that, that it was quite obvious that, like someone was looking through my things, and it was quite messy after that, and yeah.
Okay. So the deputy testified that they found a set of keys and some beers on the person of Mr. Silvas. The keys, did you get a chance to look at the keys?
Yes, sir, I did.
Okay. Are they yours?
Yeah, so I asked permission first just to look through the things that were taken, and I had noticed that my spare keys were one of the items, and then I just asked permission if the officers can check and to confirm, yes, it was the keys to my place, spare keys.
Now, did you know Mr. Silvas before that night?
No, sir,
You'd never seen him before?
never.
All right, that's all the questions I have, Judge.
Mr. Koch?
No questions for this witness, Your Honor.
Is the witness released?
Yes, sir.
Thank you very much, sir.
Thank you, sir.
That's all the witnesses I'd like to call.
All right. Anything from the defense?
would like to get some testimony from my client regarding where he lives for some bonding.
The 903-046 factors?
Yes, Judge.
Okay, you can do that at the lectern.
Yes, Judge.
Raise your right hand, please. Do you swear or affirm testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, you can put your hand down.
Thank you, Your Honor. Can you please state your full name for the record?
Eric Silvas,
If released, Mr. Silvas, where would you live at?
224 Stedman's Court, Funiac Springs.
Who lives at that address?
My father,
Does he own that house?
yes.
How long has he owned that house?
Oh, let's see, 25, 45, 20 years now. The house alone, the property much longer.
How long have you lived in and around this area?
43 years, March 30th. Maybe 44.
If released, do you have employment opportunities?
Absolutely.
What are those?
An electrician and also flipping burgers with McDonald's. I thought it was time for a change, but most definitely electrical.
So how did you get in the electrical field, or what kind of business is this?
I started doing electric when I was 18 years old. And the last company, the gentleman passed away, God bless him. I stayed with him for 5 years. So after that, that's pretty much what I've done mostly.
Now, what kind of assets do you have?
Nothing at the moment. I'm at the very bottom, climbing up, starting fresh, brand new. It's wild.
Do you have a car?
No, sir.
Do you have a bank account?
None.
Now, if this court imposes a GPS monitor on you, would you abide by that?
Yes.
If this court imposes mental health pretrial services, would you abide by that?
Yes.
Would you maintain contact with me, your attorney?
Yes.
Would you show it to every court date?
Yes.
No further questions, Your Honor.
Nothing from the state.
All right.
Sit back.
Arguments?
Yes, Judge, the state believes that the four factors of 907-041, 5C5 have been met. Mr. Silvas is charged with an armed burglary that's listed as a dangerous crime. It's 907-041, 5A16. The testimony from the deputies on scene had an eyewitness that led them to where Mr. Silvas was trying to force entry into homes while he was armed with a fixed blade knife while threatening to kill he said some expletives there, but he resisted, reached for his knife while he was trying to get out of the grasp of law enforcement officers. All of this, you heard testimony from two of the deputies that were on scene that witnessed it and saw it. So there's the requirement that there's a substantial likelihood that he committed the crime, I believe, is met there as well. The factual circumstances indicate that Mr. Silvas was not really thinking about the safety and well-being of the community. In fact, he was threatening to kill certain members of it. So I believe that prong would be met there. As far as any other safe ways to, or conditions of release. I mean, I don't know how that, I don't believe there are any. When someone is intent to harm someone, GPS monitor is not really going to prevent that. That unfortunately scenarios happened, and I believe that for the safety of the citizens of our county, Mr. Silvas needs to be held without bond until this case is resolved. So, that's the state's position.
Yes, Judge. I just briefly want to, for the testimony today, these alleged facts, especially from the sergeant who stated some post-Miranda statements from my client, put them inside that 3307 apartment, and that's the nature of the armed burglary. But I do want to push back on being armed during that burglary. Just looking at the jury instructions for a burglary, and they describe being armed. It's being armed with an explosive or dangerous weapon, and it goes into an object, that dangerous weapon, an object to inflict bodily harm. An object not designated to inflict bodily harm may nonetheless be a dangerous weapon if it was used or threatened to be used or intended to be used in a manner likely to cause death or great bodily harm. I'm pushing back on the armed burglary testimony from Deputy Hennis. I believe he stated 3 inches, pocket knife. They did say it was in an open position. I had no testimony that pocket knife was used in that burglary, so I push back on describing it as an armed burglary. Not minimizing a burglary, but I just want to push back on that element. Moving forward, I'm requesting that there are some safeguards to protect this community. Because I heard that was that's a valid reason to hold someone pretrial detention. Looking at the cover sheet from first appearance, I see, first of all, 0 failure to appears. That's what it's notated on, Judge. I want to point that out. My client gave testimony. He can live with his father, who's lived there for 20 years in Defuniak Springs. He can apply with any mental health pretrial services. Of course, I'd impose that weekly in-person check-ins, also that ankle monitor, Your Honor. I did go in some testimony from my client about what he could afford for a bond. He said he had nothing, no bank account, no assets. So I am asking for the burglary. I know it's charged, armed burglary charge, for $100,000 on that count, Your Honor. For the resisting without and the petty theft, $2,500 each. And of course, imposing all the pretrial services that I listed, respectfully.
Response?
Well, I believe that when Mr. Silvas told the police officers that he was there to kill people, and he had a weapon, a modified knife, to where it wouldn't close, and the violent nature in which he chose to enter the apartments there clearly show an intent to go in and cause harm. He went into apartment 3307 and cased it and looked around. Thankfully, no one was there. So I believe the armed part of the statute there, the jury instruction that counsel just read, I believe is met here. And as far as the community and safety, even like you brought up the first appearance sheet, he's got 6 prior violent felony convictions, 5 misdemeanor violent convictions, a total of 13 prior felonies. This is he's got a track record, Your Honor, of violence, and it's the state's position that our community isn't safe with Mr. Silva's out there right now. So.
All right. Anything else?
No, sir. Not from the state.
Nothing from the defense, Judge.
All right. Based upon the testimony I've heard and the addendum of probable cause, which is in the finding of probable cause at first appearance, together with the pretrial documents which were supporting the first appearance, there's a substantial probability based upon the defendant's past and present behavior and the criteria which have been announced under 903046, both by the defense and by the state regarding the prior criminal history and the other relevant facts that we've heard here, that the 907041 5C factors are present. And the court has been careful to observe also the behavior of the defendant during this hearing, and the defendant's behavior during the hearing, I'll just say, appears to demonstrate a lack of concern for the testimony or the circumstances presented and the consequences of the dangerous behavior which has been testified here to today, and the conduct demonstrates a disregard for the seriousness of the proceedings here, and the court has taken that into consideration in evaluating the testimony of the defendant and the other circumstances. And the court finds that the state, based upon the testimony here, has proven that pretrial detention is necessary beyond a reasonable doubt, particularly considering the defendant's prior criminal history with the convictions for violence and the possession of a dangerous weapon in this case. And I understand your argument. The court's understanding of prevailing law at this time is that an ordinary pocket knife is not considered to be a dangerous weapon unless it's used as such. However, this pocket knife was modified to become a fixed blade, and by definition in the prevailing law, that is a dangerous weapon in and of itself. And the circumstances presented where the defendant appeared to be trying to reach this weapon during his detention would suggest that he has a complete disregard for the safety, even when he is in imminent risk of his own life being detained by officers, which demonstrates that he has no regard for public safety or concern for anyone else. And the court finds that that's a definite factor in determining that pretrial detention is appropriate. And therefore, there's a substantial probability the defendant committed the offense, and based upon the defendant's past and present patterns of behavior and consideration of the criteria 903046 and 907041 and all of the other relevant facts, no conditions of release or bail will reasonably protect the community from risk of physical harm and ensure the presence of the defendant at trial, or based upon the defendant's behavior here today in the courtroom, assure the integrity of the judicial process, and therefore pretrial detention is ordered, and the defendant shall be held in the Okaloosa County Jail until further order of the court.
Don't make any statements.
Oh,
No statements.
I don't want to make a statement.
Dude, it's over. Just call the deputies at this time.
Can we go trial by judge?
Just go follow that door.
Yes, sir.
All right, and I'm going to have to take care now of a matter that's been assigned to me that by the Chief Judge in Escambia County. We're going to do it remotely here in the courtroom, so Madam Clerk, I'll be queuing them up for this proceeding. I may just need you to help me with any dates that I need, okay? Say again. And Good afternoon, Madam Clerk in Escambia County. You able to hear us and participate meaningfully?
Yes, sir.
24 CF 3007, and that's Escambia County. Yes. All right. Yeah. Well, hold on, let's see who we have at 1:30 in the courtroom. Let's go ahead and clear those folks out before we get to our inmates, okay? Let's get them back out onto the,
Your Honor, I have some present in the courtroom.
all right, call them up.
First, I have Miss Heidi Lopez Torres. Case number 25 CF 2369. Do you have the information?
Yeah. Okay.
Your Honor, I will acknowledge receipt of information, waive formal reading, enter a plea of not guilty, and ask to leave this set for the next court date, which I believe is March 9th.
Set for March 9th, or?
I also have it set for the 21st for the mental health court.
Yeah, she's currently in mental health court on another case. So this is tracking with that also.
Okay, so do we want, is it the state's agreement that this case would track with the mental health court case?
We haven't discussed it yet, Your Honor. I haven't discussed that with Mr. Gomez yet.
I guess what I'm trying to say is I don't want her to come to court two separate times if we don't need to.
Does she have a separate case in the mental health court?
Yes.
It's, I think she has a separate case in the mental health court.
She has a VOP that's in mental health court.
I don't know, I feel like this case would get lost if you put it on the mental health.
Okay, we'll put it on 3/9, then y'all can chat about that.
Yes, sir.
Okay, stay in touch with Mr. Cochran, and he'll let you know whether or not you need to be at both cases or not, okay? But plan on being here on the 9th unless he tells you no, okay?
Yeah.
Okay, thank you.
Still good.
Charles. I asked Fran to bring you a cup of water. She's going to bring it to the back door. Thank you.
Your Honor, I also have Mr. Robert Lucero Durgan. Case number 25 CF 2418.
Yes, sir.
Your Honor, today we will acknowledge receipt of the information, waive formal reading, enter a plea of not guilty, and ask to leave this set for the next court date.
And that date is, Madam Clerk?
March 9th.
3/9. Stay in touch with your lawyer. You'll be back in court on the 9th, okay?
Yes, sir. Thank you.
you.
And I believe that's all I have present at the moment.
10-4. Mr. Jeffrey Parker, 25 CF 2419. If I may approach, Your Honor.
Granted. Thank you, Charles. Thank you.
Mr. Parker is present with me. We're going to acknowledge receipt, enter not guilty, waive formal reading, request this be kept on that 3/9 pretrial docket.
So ordered.
This is our next court date together. But before that, we're going to call make an appointment with me. All right, free to go. Next judge, Mr. Mika Sutton, who's present and approaching. This is 25 CF 2403. I'm sorry. Your Honor, I acknowledge, received the information. We're going to enter not guilty on all counts, waive formal reading. Request this be kept on the 3-9 docket.
So ordered.
3-9's our next court date.
And State, be sounding off if you've got an offer on any of these things, please.
Before then.
Oh.
All right, take that, you're free to go.
They
sir.
have our offers.
Yeah, I'd like to hear them in open court.
Got
That
it.
way we,
Yep.
That's all everyone has present.
Do you want me to give you the offers that I have for Parker?
you know, the next ones that come up, let's. Mr. McKinney, Minnie out of custody.
Judge, I do have one, but it's one that we're working on with Mr. Eugene Tile.
Okay. And then I show Timothy Rawlings. Timothy Rawlings?
Yes, sir.
All right, Mr. Rawlings, you're here today without an attorney. Do you want an attorney to help you, or you'd like to hear what the state has to say as far as the disposition first?
I did obtain an attorney. He just is not here today.
Who is your lawyer?
Mr. Durrell.
All right. Is there a written plea not guilty?
I'm sorry?
I'm asking the clerk to check the record.
Looks like one was filed today. Mr. Durrell.
All right. So the written plea not guilty was filed today. You're set for 3-9, is that right, Madam Clerk?
That's correct.
All right, get in touch with Mr. Durrell. Be back on March 9th.
Thank you.
Thank you. Good day. Richard Whitfield. All right, Mr. Whitfield, you're here today without a lawyer. Do you want a lawyer to help you?
Yes, sir, I was going to request Mr. McKinney to give me a
Okay.
lawyer.
All right.
That's all right, number 6.
And the amount you've listed here is your pay, that's what you take home every week?
Sir,
Is that what you take home every week?
I've been making around 400 a week, sir.
And that's your take home?
Yes, sir.
Are you responsible for your own taxes, or do they take it out for you?
I've been paying, I'm responsible for my own taxes.
Okay, so that's before your taxes or anything else, right? And that's what you average over the year?
I just got a job, I just started 3 weeks ago.
Okay.
Not even a month yet.
Okay. All right, so I'm going to reduce that by just the Social Security and Medicare that you'd have to pay. And that brings that down to that amount. I just did a simple math calculation because you would be entitled to use your net pay. So I'm going to reduce that by that amount. Do you agree?
Yes, sir.
Okay. All right. It appears you do qualify, and I'll appoint a public defender to represent you. The clerk will review this. If they say you don't qualify, they'll tell you why. And if you think they're wrong, then get everything shows that they're wrong and give it to your lawyer and bring it with you to court next time. A lot of times something would be like, they say you own a car and you sold the car or it's junk or whatever, provide that evidence and bring it to court with you next time. Mr. McKinney.
Judge McKinney, on behalf of Richard James Whitfield Sr., 25 CF 2353, we would acknowledge the receipt of 2-count information. Does the state have a current offer for Mr. Whitfield?
No, sir.
Judge, we would enter a not guilty plea and ask for the next available pretrial.
3-9.
Thank you. Any better we could do something else and then make contact with the
All right. Yep.
Kara Litz.
That's you, Mr. Cochran, I believe.
I'm sorry, Kara Litz, right here, yeah, 38.
Copy of the information.
Your Honor, we have Ms. Kara Litz, case number 25 CF 2416. We acknowledge receipt of the information, waive formal reading, enter a plea of not guilty, and ask leave this set for the March 9th court date.
Your Honor, the current offer is to resolve both this case as well as a VOP in 25 CF 488.
25 CF 488.
Yes, Your Honor. The current offer is adjudication of guilt, revoke and terminate the supervision in 25 CF 488, and be sentenced to 14.63 months in the Department of Corrections. And that would be what the guidelines would show.
Okay. And the VOP to travel with on 3-9?
Yeah, not on probation. No. No. No.
Open VOP and
We're continuing to 3-9, Your Honor. I'll look and figure out the VOP issue between now and then.
All right.
Yeah, I'm not on probation.
I'm figure out why you're saying
All right. Thank you very much. 3-9 it is.
Thank you.
Next we have Deja Terry.
Jason McKinney on behalf of Ms. Terry. This is 25 CF 2186. We would acknowledge the receipt of a 2-count information, waive its formal reading, enter a plea of not guilty. Is there an offer from the state at this point?
3 years of probation. That's the standard conditions.
Judge, may we call her back so I could discuss the terms of that offer with her?
Absolutely. So Ms. Terry for a plea.
Yes.
Yeah.
Next we have LaTanya Williams.
Judge, Ms. Williams is here at 25 CF 2381. Has an information been filed in this case?
Yes, this one.
I printed it, Judge. It's a 6-count information. I will waive its formal reading, enter a plea of not guilty, and ask for this to remain on the next available pretrial court date. Your Honor may see Ms. Williams for motion practice ahead of that date, but we'll enter a not guilty plea for today.
All right, is there an offer?
Still trying to determine some things with my victims.
Judge, given the age of the case, I would be seeking to investigate the statute of limitations. So at this time, that I would maintain the not guilty plea.
Understood. And if you get your motion filed, we'll set it as soon as practical.
Thank you, Judge.
This will be Samuel Olmsted, which is Buckner.
One second, Mr. Olmsted has more than one case.
Madam Clerk informs me that there's a VOP 22 CF 2951. It's not currently tracking, but we'll hook it together.
That's correct, Your Honor.
Yes, Your Honor.
Enter a denial.
We're entering denial on the VOP, Your Honor. As per the new law, 25 CF 2346, will acknowledge receipt of 1-count information, waive formal reading, enter a plea of not guilty, and ask the meeting to set for the March 9th court date unless the state has an offer they want to.
The current offer, Your Honor, is to resolve both cases.
All 3 cases, right?
2 cases.
There's 2.
2951, 2346. Okay, yeah, sorry.
Okay, I just want to make sure I was about to be wrong. It would be an adjudication of guilt, provoke and terminate supervision in the 22 CF 2951. sentenced to 17.7 months in the Department of Corrections. That is a guideline sentence.
17.91?
17.7.
And that's the guidelines?
That is, Your Honor.
So, Your Honor, yeah, we would, today we'd ask to leave this set for the 3/9 court date.
All right. 3-9, so ordered.
Thank you, Your Honor.
Go here, this is yours. Thank you. What's the name? O'Neill.
Yes, Your Honor, we have Mr. Marquell O'Neill, case number 25 CF 2383.
Is there?
Your Honor, we have a 4-count information. We acknowledge receipt, waive formal reading, enter plea of not guilty, and ask to leave this set for the 3/9 court date.
Offer?
As of right now, Your Honor, there isn't one. I need to speak. Our victim advocate has reached out and has spoken with the victim, but I want to meet with the victim myself based on some of the victim advocate notes. I can say that based off of the victim advocate notes that I do have, this will be a DOC offer, even though the defendant does not score a guidelines prison sentence. The offer will likely be DOC.
All right.
So set for 3/9. If we get a plea before that, I can bring them up.
All right. Thank you. Good day.
Once I have more info, I'll go do that.
Next, we have Michael Thompson.
Your Honor, before he gets to this podium, one of my 230s is going to be continued. He's here. If I could just address it so he could,
All right, sure. Who is that?
that is.
Trenton Lindsay.
Trenton Lindsay, case number 25 CF 2083.
Okay. Go ahead.
Your Honor, this is going to be a continuance for the motion to suppress. The witness isn't available.
If we could set it for the next available miscellaneous date, we'll work to see if we could resolve something, if I can make an offer before that. But if we could just get the next miscellaneous date for the motion, so I can go ahead and get subpoenas out.
Well, we got next week, but it's pretty piled up.
That would be tough for me to make sure that.
Okay, 2/12.
2/12.
Next court date.
Right, Madam Clerk?
That's correct.
Okay. All right. Stay in touch with your lawyer, Mr. Lindsay, and be back on 2/12. If there's a resolution, they'll let you know that if you don't need to be back, okay?
Yes, sir.
All right, thank you now.
Next, we have Michael Thompson.
Judge, this is Michael Thompson, for the court in 25 CF 2376. Judge, I was just appointed on Mr. Thompson's case, I believe on 1/8. I would request a continuance. I'll enter a not guilty plea on the 25 CF 2376. Ask for this to remain on the next available pretrial day. I do see a 2-count information waive its formal reading. I am in discussions with the state and trying to get to an offer to resolve the matter.
3/9, is there an offer or not yet?
It's incarceration. He wants to work on the amount.
Okay.
I'll come talk to you as soon as I get out of the file. So we get something worked out ahead of time, in which case we just get it in court ahead of time. I'll come see you as soon as I get out.
Next, we have Mario Trujillo.
Judge, this is Mario Trujillo, 25 CF 2397. We would acknowledge the receipt of a 3-count information waiver formal reading and a plea of not guilty, and ask for this to remain on the next available pretrial court date.
All right, 3-9. Is there an offer?
State prison. Not, haven't determined an amount at this time.
All right, 3-9 it is.
And Judge, may we place Mr. Trujillo into the attorney-client room after this?
Yes. Well, as long as they accommodate, I don't know what the situation is. Okay, yes.
All right, thank you.
We're not going to get back to work.
No.
Right, who is the Trujillo? Chase Payne?
Mr. Chase Payne, 25 CF 2365. If I may have a brief moment. Judge, Mr. Payne's going to enter a plea this afternoon of no contest. We'll announce the terms. Counts 1 and counts 2, the felony charges. This will be adjudication of guilt, 5 years standard probation, $40 per month cost of supervision, $615 in court costs, $150 defense costs. There's 48 hours community service, no contact with Devin Chavrist, no trespass at 748 Mayflower Avenue. That's Fort Walton Beach, Florida, 32547. Must complete a substance abuse evaluation and any recommended treatment. We're going to reserve restitution for 180 days. I also handwrote in another term here. No contact with Pauletta Chevris Leonard. Myself and my client both initialed by that. Counts 3, 4, 5, the remaining misdemeanors, adjudication of guilt, credit for time served. All counts to run concurrent. If I may approach with a signed plea form and a score sheet.
Granted. That's the state's agreement.
It is, Your Honor.
Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you put your hand down. You heard what Mr. Koch said on your behalf and signed the written plea form? Did you sign the written plea form?
Yes, sir.
How old are you?
40,
How much education do you have?
11th grade.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read in the plea form, what Mr. Koch just announced to me.
Yes, sir.
Do you understand by this plea arrangement that you're pleading no contest to the announced charges?
Yes, sir.
And that tells me you believe the state can prove your guilt and you're not going to contest that.
Yes, sir.
Do you understand by doing this, you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir.
In this case, you'll be adjudicated guilty beyond 5 years of probation with the fees and costs that were announced, the community service hours, no contact with the person announced, no not be at or about the place announced, no substance evaluation and recommended treatment, and restitution may be established, and also no contact with the second person that was announced. Is that what you understood?
Yes, sir.
Mr. Koch answered all your questions about the plea and how it affects you.
Yes, sir.
And are you satisfied with how he's represented you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea.
Yes, Your Honor. Take that copy with you.
If you'll step over this way for the bailiff, please.
Michael Sillers next.
Judges, Mr. Michael Sellers, 25 CF 2432. Is there a, if I may ask for this to come off? Thank you, Judge, for the additional time. Speaking with Mr. Snell, he stated this would be an incarceration offer, so nothing that could get you released today. So I'm going to enter not guilty, waive formal reading, request this be kept on that 39 pretrial docket, Judge.
All right, so ordered.
Next will be Adam Stevens.
Adam Blake.
Judges, Mr. Adam Stevens, 25 CF 1350. If I may approach, Your Honor.
Granted.
Oh, thank you. Your Honor, if I have a moment to speak with Mr. Snell for a potential offer. Judge, speaking with Mr. Snell, there's currently adjudication of guilt and a 3-year probation offer on the table. If I may discuss that just briefly with my client, Judge.
Yes, sir.
if I may pass up Mr. Stevens, I'm going to get a plea form for that 3-year probation offer and speak with him about it, if we can hold him.
All right, if we'll hold Mr. Stevens, please, for a plea.
Thank you.
Judge, may I call him out of the gallery?
Yes, sir.
That would be Eugene Ty Jr. Mr. Ty is present and approaching in 25 CF 2310. He is on for arraignment, however, we have resolved the matter. Mr. Ty is going to be able to plead to 2 lesser included offenses of possession of paraphernalia, based on him having a valid medical marijuana card. Madam Clerk, that's going to be 893-147, sub 1. The agreement is for time served with an adjudication of guilt to the 2 misdemeanors, $270 in court costs, $150 cost of defense. Mr. Ty would ask for 60 days to pay those amounts.
Granted. Raise your right hand for me, please. Do you swear affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you put your hand down. You heard what Mr. McKinney said, and you signed the written plea form?
Yes, sir.
You understand you're pleading no contest to the announced charges and waiving your right to a trial by jury?
Yes, sir.
You'll be adjudicated guilty. You'll have the fees and costs that were announced and sentenced to time served.
Thank you.
Mr. McKinney answered all your questions about the plea and how it affects you?
Yes.
You satisfied with what he's done for you?
Yes.
The court will find the plea to be freely and voluntarily entered into and accept the plea.
Thank you, Judge.
I'm sorry, how long will we give him to pay?
We would ask for 60 days.
60 days. It's a POP, Charles.
You need your prints?
No.
No. Thank you very much, Ms. Ty.
Thank you, sir.
Good day.
Your Honor, if I may call 2 that are in the courtroom.
Yes, sir.
Mr. Ronnie Lowe, Your Honor, 25 CF 2408.
Yes.
This guy Raquel is right inside the feed. He said he'd like to speak with you for a minute before he comes in. If you want to step in there and speak to him, it's up to you. Yeah, I told him you didn't have time for that.
Thank you.
Your Honor, we acknowledge receipt of a 1-count information. Will waive formal reading, enter a plea of not guilty, and ask to leave this set for the 3-9.
Is there an offer?
There is, Your Honor. It is adjudication of guilt, 2 years of probation, $45 to James Smith, 48 hours of community service work, no trespassing at 44 Magnolia Avenue in Shalimar, Florida.
$48 of...
$45 to James Smith.
All right. All right. And so 3-9?
3-9, Your Honor.
All right, very good. Stay in touch with your lawyer. You'll be back on the 9th. All right.
The other, Your Honor, Mr. Jeffrey Melvin. Case number 25 CF 2449. Your Honor, today I would like to acknowledge receipt of a 1-count information, waive formal reading, enter a plea of not guilty, and ask to leave this set for the March 9th court date. I have gone over an offer with my client.
Say again?
There's no offer.
No, excuse me, yeah, this one didn't.
There hasn't been an offer on this particular case, Your Honor. This is an interesting scenario that happened in May of 2025. We're trying to establish contact with the victim before we give a formal offer.
Okay. Stay in touch with your lawyer. If he gets an offer, we may bring you back sooner, okay?
Sir.
All right, thank you now.
See you 3-9.
That's it.
All right. Have a few other folks in the courtroom. Mr.
If I may call one, Judge, Mr. Alex Smith. Mr. Alexander Smith, this is 25 CF 2430. You stand right here, Mr. Smith.
Adjudication, 36 months.
There's currently a...
Standard conditions.
Yes, sir. There's currently a 3-year probation offer on the table. How about, I'm going to enter a not guilty, waive formal reading, so we can talk privately at my office. 1 second. 1 second. It might have just a brief moment, Judge.
Yes.
One second, it's fine. Judge, we'll be entering not guilty, waive formal reading, request to be kept on the 3-9 docket.
All right. Mr. Koch, you can't help but observing your client's behavior. Is your client okay?
Yeah, almost, I'm sorry.
He's fine, Judge. I asked him, he said he's fine.
Is this his normal presentation?
This is the first time I've met him, but I do want to speak privately, and we're not going to enter any pleas today.
I mean, the court simply has a concern that he may be presenting himself in an impaired state based upon his behavior.
1 second, 1 second. Judge, if I have just a brief moment.
Yes.
Here, stand right. He's just a little, there's some facts about this case he wants to discuss, but I told him we discuss in my office. And I guess he's really agitated about it.
Okay, so I just want to caution the defendant that, part of his responsibility of being here is being present. And being present means being in a state to know and understand what's going on. And if he is in fact impaired, then he is not present. And the court takes that very seriously, and just have concerns based upon his behavior that he is in fact present with us right now. And if the behavior continues at a next court appearance, he should expect that he'll be asked to take a test, and if he tests positive, then he'll probably be held in contempt and his bond revoked and sanctioned, because I can't very well take a plea from someone who's impaired and not have their judgment properly in place. And although this is a material stage of the proceeding, it is a not guilty plea, and you're asking for the matter to be set. But I'll give you a moment with this sound on to explain to your client the seriousness of the court's admonition here and the consequences of his failure to appear in a proper state.
Absolutely. Thank you, Judge. I explained the situation. My client did apologize, and he knows next time he'll be squared away.
All right. All right. Stay in touch with your lawyer. Be back on 3-9 or when he sooner advises you.
Thank you, Your Honor. Sorry, Your Honor.
Take this. You're free to leave. Call and make that appointment. You're good to go.
All right. All right.
For which one? I have no one left.
The Bob Kell Stewart, Mr. Cox.
10-4. Judge, Mr. Rob Hill Stewart in 25 CF 2384. Acknowledging information, if I may ask, is there a current officer? Mr. Rob Hill Stewart.
Yes, that's 3 years of probation, adjudication.
If I may just have a brief moment to explain that, Your Honor. If we can hold Mr. Stewart, I'm going to type up that plea form, Your Honor.
All right.
Thank you.
Hold Mr. Stewart for a plea, please.
Thank you.
Thank you. Yes, sir.
Your Honor, we have Mr. Giant scheduled for judgment of acquittal and for sentencing this afternoon. I don't know if the court wants to go into that now, or if we want to finish the 130 docket.
And I believe the judgment of acquittal was addressed at our last court date.
No, we never got an order on the judgment of acquittal.
Okay, well, let's finish our 130 docket so we can get that all squared away, and then we'll get to Mr. Dunn.
Or the two, this is 2 o'clock docket.
Right. But let's finish our arraignments, and then we'll get to the other docket. Okay? Okay.
It's on the minute sheet from 12/11. It's on the minute sheet from 12/11.
Because how many we got left on the 130?
It was addressed.
On the arraignment
Remember you
docket.
had to leave, the judgment of acquittal was addressed and denied. It's in the minute sheet.
And then I'm just showing Riley, Gines, and Lovelace left on the,
We have a LaBelle in the 130 docket.
no, right, on the 230.
Yes.
Riley,
That
Gines,
sounds
and
accurate.
Lovelace.
Yes, Your Honor.
That's who's left,
Yes,
okay.
Judge.
So let's keep going on the 130, get that finished. We'll take a comfort break, and then we'll come back to the 230.
Maybe I'll have that couple ones I have with their custody, so I wouldn't have been out to come back with a plea or Giants rally or whatever he wants.
So Stewart that we sent that, Stevens that we sent that, and Terry that we sent that.
Those three,
Right.
and then all of that, Giants rally and all.
All right, so why don't you, so why don't you call the ones that we haven't got to on the first, not the first appearance, on the 130 docket.
First one I have is Brandon Rebella.
LaBello, please.
Yes, Your Honor. Mr. Lobetto has 2 matters on the docket. I don't have the case numbers in front of me. I just
25 CF 2388, 25 CF 2389.
Your Honor, he is not present. However, he was in my office Tuesday. We had a face-to-face. I did tell him I was going to have to withdraw. And I don't know if that caused confusion on whether or not he needed to be here today. I would ask that the court give us a day next week so I can get in contact with him. It's not a situation where he's not doing what he's supposed to. He's,
Okay. Well, we were here for arraignment, right? When's our next arraignment
We
date,
will
madam?
continue to arraignment on January 22nd.
Say again?
January 22nd.
All right, we'll put this, then we'll move the arraignment to 122.
thank you, Your Honor.
Get your motion filed so that
It
we
is
get,
filed.
all right. And so we get Ms. Jaquith on as board.
And there's a proposed order already filed also, Your Honor.
All right.
Next one's Jenny Soto's Duenas. Case number 25 CF 2404 with Mr. Koch.
Soto Duenas?
Jenny Soto Duenas?
I'm sure that notice was just sent to the bondsman. Anyone else, the bond paperwork is listed today at 1:30.
All right, were you able to hear that?
Yes, Judge.
Okay. Issue of capias. And then Azel Perez.
Your Honor, 25 CF 2417, Asel Perez, that case was no pros, January 7th.
That's correct, Your Honor.
That's correct.
All right, thank you very much.
Case is over, dismiss is done with. Free to go. You're welcome.
Carter Spain.
Judge, we addressed that this morning.
That's what I thought we did, right?
Yes. And so we kept that on that 3-9 docket.
Okay. And the only other ones we have are the ones we're waiting for your plea agreements on, right?
Yes, Judge, I got 2.
All right. You ready, or you need a little minute?
Need a little more time. I'll
Okay.
print them out
All
right
right,
now.
we'll take our break now and let you get those finished, and then we'll queue up for those and for our 2 o'clock. Now, on Loveless, what are we doing on Loveless? That's a motion